Was that a 150?
Oh.
He won't, he won't.
You said it's a Ford?
Yeah, it's XLT with.
Is that kind of basic?
No,
I know
it's
one or
like
two
that
other
range.
attorneys
It's
in
got-
town.
It's got the now.
It's less than
Oh.
a Lariat.
It's less than a
I don't
Lariat, it's
need a
cloth
Lariat.
seats, but about it working,
Yeah.
it's got the,
Being lack of
the plug. with power
the
inverter.
chairman and the vice chair not being here, I will make a motion that Paul run the
I
meeting.
just don't need it for my business.
Okay, well, why don't we
We have to
wait,
wait-
yeah, until the meeting opens and all this, and then
I'm
you guys can
I'm
decide.
opening the
I'm gonna
meeting.
be putting it up.
Yeah, he is, yeah, he's gonna,
Yeah.
He's gonna open the
Yeah.
meeting?
Yeah.
Okay.
Yeah.
And hold on, I'm working with technology
I'm not sure if I should thank you though, or if I should come over and
My-
shake some
my
sense into
mother-in-law
you.
No, you're gonna get it.
who lives in Kansas City, bought a car to drive to camp when she was overseas in the summer, and sticks it in my garage. I said, well, if you don't need it in winter, I'm gonna drive it, and I'm not gonna be, extra car that's just sitting there. So, I was like, well, I just got this Audi that I got here, which I would never drive. It's an old summer old car that she got.
I just love it. For years, I don't know why I didn't get one in years ago, my husband always had a car. But he just goes to work and sits in the parking lot, and I need it.
You what?
Move to your left a little bit. So I can get the Allen.
My husband's been a lawyer too.
I wanna give him more room. I wanna get close to you.
Sorry, this is the fun stuff.
Okay, I'm Alan Plummer, I'm the code enforcement officer. We are recording, live streaming on YouTube as well, and it's, you can look later on and see that on our channel. So, we have a quorum, so if we could just go around the room and just state your name. We'll start with Milt.
Yep, I'm Milt Simon, I live on the Stackpole Road.
Terry Kirk, Newell Brook Road.
Paul First, Chesley Hill Road.
Neil Berry, Stackpole Road.
Byron Filbert, Sunset Lane.
Everyone is an active member. Byron is an alternate, just so you know. 4 is required for a quorum. We have that. Our chair is not present, and it says in our ordinances that we can elect a interim chair or temporary chair. Acting chair, yes, that's right.
Can I make the motion?
So, yes, if we could have nominations.
I'll make a motion, Paul first.
I second.
He just seconded.
Second,
Oh, okay.
any discussion? Nope.
You're it, buddy.
And a vote, a show of hands. All those in favor, any opposed?
Abstain.
Okay.
Doesn't work.
That was abstain.
So our
I vote yes.
chairperson for tonight is Paul First, duly elected by this body.
Okay, thank you, Alan. Welcome, everyone. So, we usually start these meetings with a pledge, and I'm just thinking, just to, honor how we always do it. Why don't we, civility and all those other things.
I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Chair, just make a comment that the notices have been duly posted in the newspaper and in the town office, the website, and so forth, so that's been taken care of. I am the administrative person only for the Board of Appeals, so I'm gonna be taking notes. I have no interest or say in how this deliberation goes. I'm here also to answer questions if there are questions that I might have.
Mr. Chair,
Yes.
Secretary, do we need to deal with that?
We might as well. So I don't believe we currently have a secretary of record. So, and the ordinance clearly states that we should have a secretary.
I make a motion, Neil Berry be our secretary?
Who?
Neil.
Works for me.
Ah,
I'll second it.
okay. So we have a motion here by Milt and a second by Terry for Neil Berry to serve as secretary. Discussion?
Yes. Normally, Neil, what they have done is the recordings they're making, if you have any questions, you can go back to the recording and kind of make your note.
Terry, yeah, we can discuss duties, I think, after the meeting.
Yeah.
Yeah, okay. All right, so further discussion. All those in favor? Okay. And I think also it might be helpful for us to talk a little bit about the alternate role, since we're very fortunate. I'm really pleased that we've got actually two members here tonight that haven't been here before, both Neil Berry and Byron Philbrick. And that's wonderful. Thank you both for stepping up and serving. So the way the alternate role is designed in the ordinance, Byron, is that if we're less than 4 members, then we'll make a motion to appoint you to serve in that role. But I know traditionally when I served as alternate, and I served for many years, then the alternate was still able to ask questions, you know, and participate in some discussion, but not to vote. That's my recollection. Is that your recollection too,
Yes,
Milt
yes,
and
yes.
Terry? Okay. So I think that's a good tradition, you know, for us to continue. And so, but we're really looking forward to hearing your thoughts tonight on the application, and I'm sure there will be many meetings where you'll be called upon to also to vote and serve directly as alternate. Okay, so we're here tonight to hear a variance request from the, is it Frev family? Frev family, okay. Freed? Freed, from the Freed family. Thank you. At 12 Rabbit Road, related to the side setback of a garage. And is the applicant represented this evening by their attorney?
Yeah, through counsel, Michael Malloy from Auburn.
Okay, Michael Malloy.
Yeah,
Reminder to have your microphone pretty close to you when you're talking.
and Eileen and Terry Freed are both here. Yes.
Okay. Yep, okay. Both applicants are here. Is the builder also here this evening? No, okay. And we have a number of community members, and there is a public hearing portion of this hearing also. And I believe we're also joined by the real estate agent?
Yeah.
Yep.
We all are part of the transaction.
Okay, yes, and also the buyers.
The other agent and the
Yep.
buyers.
Oh, very good, thank you. All right, so I'd like to suggest that we start this evening by just basically kind of agreeing on how we're going to, what the structure is going to be of the review this evening. I thought that might be helpful, just to make sure we're all on the same page, and also since I'm new to the chair position. So my recollection is at these meetings that Barbara would always start with a list of the evidence and Gary that's been provided for the record, just to list that out. And that helps us when we're writing the decision, include that information in the decision, so all those things are there. So I'd like to start there, and I'd like to follow that by the case statements. I'd like to hear a statement of the issue or the case from the code officer, from Alan, and then from the applicant. And then the applicant can come up and provide their statement and the issue as they see it. And then for us to have, and for us to let them make their statements, and after both of them are done with their statements, we can, as board members, ask them questions. Ask them questions. And then to follow that by the public hearing, then we'll open the public hearing and allow any members of the public that are here that would like to speak, close the hearing, followed by any further discussion, and then we can, do things like look at the ordinance and the criteria in the ordinance, go through those, and hopefully come to our decision and findings. Does that make sense to everyone here this evening? Okay, very good.
Just, if I may, Mr. Chair, we have a few additional submissions of evidence we'd like to offer to you.
Okay.
You have to do that when you're ready for us, or if you're gonna go through
Well,
that.
I'll tell you what, why don't I put into the record what we've got so far, and then you can make your additional submittals. Okay, excellent. Okay, and Alan, you're gonna have to help me here, because we've had a number of different things.
First packet that was presented to the town.
Yep, okay, we have that first packet, and what did that first packet include?
That's the cover sheet, a application to the appeals board.
Okay.
By Eileen.
Yep,
The next page is a plot plan that shows the property and the survey done by, a boundary survey, I believe, done by the mortgage company.
Mhm.
Inspection. The next item is the application for building permit. You seeing that? The front page
Yes.
looks like this.
okay, now, this is information that was submitted since our,
This is the initial.
okay, that's the
this is
initial, we're still on
the
initial. Yeah, okay, yep.
Everyone got that?
No, I don't have it.
Yep, I got it.
So I got it.
So get back on the application, so the building permit application, which is very similar to the existing, the second page of that. The building permit issue. Next is a drawing from the builder, a plot plan by A Smart Home Improvements. And then some rudimentary drawings, a rudimentary drawing of the garage,
Okay,
and then the plot.
so if I could just stop and ask what's probably a silly question here. Eileen Knight and Eileen Freed? Or is that the?
When I bought the property back in '99, I was 9,
Okay,
okay, so, and then we didn't get married until like 2015,
I see.
so.
Okay, great, thanks for clarifying that. Okay, all right, what do you have next, Al?
Okay, so that's the first thing, and then, Matt, are you here? No?
No,
Matt, presented to me this week and asked if they could submit other information, and I said yes. So that is, this packet, request for variance, 12 Robert Road, it's like this. Okay, and does someone wanna, I have only briefly looked at this, does anybody wanna talk about what's in that?
Well, let's just go by the titles on the cover page if we could.
Yeah.
Summary of request for variance, mortgage loan inspection or loan survey showing setback insufficiency, request from Trawaji and Baldacci for no action letter, approved building permits signed by code enforcement officer. So some of this stuff is duplicate from what
Yes.
we've already received. And, it says new attachments, application of original building plans.
That's also additional.
Okay, 6, letter from a budding neighbor. 7, letter from buyers of 12 Rabbit Road. And if I could just go back for a moment and also say, I don't know if you covered this, Alan, but the other thing that we have here as part of the record is information regarding notification of the abutters. We have a public hearing notice,
Yes.
and
The abutters notified.
yep, and then what type of documentation do we have that abutters are notified, have been notified?
I have certified mail receipts.
Okay, yep,
And they were here at the last meeting.
sure, okay, yep. Okay, so I think that should bring us,
One other
are we
thing.
overlooking anything?
No, one other piece, there's an affidavit.
Affidavits, yes.
Yeah. So I don't
I've
have
got them right here.
You have them.
I have an affidavit of Eileen Freed,
Yeah.
and
I don't have that, so you have that.
I also have affidavit of Terry Freed. Okay. Let's see,
You guys need those?
I have one.
Attorney Malloy, have we overlooked anything that you have presented to date?
To date, I believe that's it, the broker submitted that.
Okay.
So I have a few additional items.
Okay, very good. Well, I think we're ready.
And I
Oh.
just have one thing.
Yep.
Initially, they asked me for a letter of, hold harmless letter, basically, or no action.
No
letter.
action letter.
So I
Request.
actually, in my previous role in a different town, I was authorized to do that. I did that.
Yeah.
I created that letter, presented that to the select board, and they did not want to progress with that. So they said, it should be coming to the Board of Appeals.
Okay,
It's my, Paul,
yeah,
it's my understanding that we don't have the authority to issue a letter of,
they've applied for a variance.
they've applied for a variance.
So rather than a no action letter, they've applied to this board for a variance,
Exactly.
rather than a no action letter. They applied to the selectmen for a no action letter,
And they were turned down.
and they were turned down. That's my understanding, or they were, I don't know how far it got.
They
But
wouldn't
they didn't
let us
They
have a
wouldn't let
meeting.
us even meet.
Yeah,
I see.
and in your
Okay.
ordinances, it states that it should go in front of the select board for a
Yeah.
consent agreement.
But I will state here before we get too far, because we are recording the meeting for public broadcast. Before we get too far into statements and everything, we want to make sure that we're able to bring people up and they can respond, but thank you for that. Okay, so, let's see, Attorney Malloy, what else do you have for us?
If you're ready for me now, I don't know, are you finished?
Yeah, come on
Yeah,
up.
From the code enforcement
Well,
officer?
no, we're not.
Okay.
Okay,
Just
but if you have additional
documentation.
information,
Yes,
if you could just give
yes.
it to us now.
Sure.
And then we'll hear from Alan, and then you can do your overview.
Sure. I prepared just a summary letter for the
Okay.
board, okay?
Yeah,
And then I have, 1, 2, 3. And then I have a law court case here for you. I believe that this was the building permit application that they have, this whole packet, so that would be duplicative. We have both affidavits, so those would be the additional items.
okay, very good.
Thank you, Mr. Chair.
Thank you. All right, so we have a letter from Malloy Firm, and we have some summaries of other cases. All right. So, that brings us down to the case statements. Usually, we start with the code officer and just ask the code officer to explain briefly the case to us and how we got here.
Okay, so I did get a call, asking to look at an email or call, I can't recall which, asking to look at the information provided, about a garage at the site at 12 Rabbit Road. It was built in, 2019, and I was told that, they got a permit, they went through the process, to get the building permit, they were issued a permit, they built the garage, and there was no issue. However, they're now selling the property, and the mortgage inspection was done, and the mortgage survey came up with a problem or a violation of our ordinance in that the garage was 6 feet from the property line when it should be 20 feet from the property line. So the requirement in all districts is 20 feet from the side and rear of the property lines and 50 feet from the front property lines. So there definitely was a problem with that. They asked for a letter from me, which I prepared, provided to the select board. And what else would you like to know?
I think that's probably fine for now. And I know I have a few questions, but I mean, personally, I don't want to get too deep into questions until I've heard from both parties. So I'm fine. Is it okay if we move on to the applicant and then we ask our questions? Okay. Very good. Yeah, come on up.
Sure. Thank you, Mr. Chair and members of the board. I'm Michael Malloy, and I've been working on this for only about a week, so forgive me if there were things that predate me that I can't speak to. First, thank you for serving your community. This is often a thankless task, and I just wanted to acknowledge that. And also, thank you to your code enforcement officer who's been helpful to the brokers in trying to find a way forward through this transaction. My understanding is that Eileen and Terry came to the town in August of 2019 and applied for a building permit to put up this garage on their property. That's the sketch that you have right there, which has some of the dimensions there that I believe would have met the setback requirements. They came in, they applied for the permit. Terry was in the town office, and at that time, the road commissioner said, I will come down and take a look at that with you. And this is in his affidavit, and followed him to the property and said, you actually need to move the garage closer to the line. It should be lined up, not with the house, but it should be lined up with the mailbox.
Can I stop you right
Yeah.
there? And
Yeah.
I just think that this point kind of needs clarification. So was this at a time when the Public Works Director was serving in that role as code officer? Like, why was, it was, and this was the initial when Terry came in for his building permit?
Right.
He initially interacted with Public Works Director rather than the code officer?
He can speak to that. No, I believe he was coming in, applying for the permit with the code officer. And
Oh, okay.
it was the road commissioner
Uh,
who said, let me go look at that with you.
okay,
So he said, okay, come on down.
yeah,
And the road commissioner said, no, that's wrong. You need to move it close to the line. It needs to be lined up with the mailbox, right on the road. And if you build it where you're planning to put it on your application, the town's gonna make you rip down that garage. So and this is the crux of their case, they moved the location of the garage closer to the boundary line in response to a direction from town officials. Okay.
Who was the code enforcement officer? The Public Works guy?
That was the road commissioner, I don't know his name.
we've only had one
Yeah,
in that time, so it would be Calvin Bomier.
yeah, Terry can speak to that, and he describes that in his affidavit. I'm sorry, I don't know his name. The garage got built, there was never a final inspection done on it. Nobody took any enforcement action or contemplated taking any. And it's, to my knowledge, the town was unaware of the apparent encroachment until this mortgage loan inspection plan was done, incident to the sale of the property. And at that point, Terry and Eileen learned that they were gonna have difficulty conveying this property. And so that brings us to the town. And so through the brokers, people have been trying to find a way forward, and certainly appreciate the code enforcement officer's efforts with the town council. They were just really looking for something to hang their hat on so that that transaction could close. Incidentally, this is the second attempt to sell this property. The first one fell through. I'm not sure exactly why. It's my understanding they got through. Conditions of the building inspection were all fine in terms of its physical makeup, but that sale passed, and this is now the second transaction that's under contract. The buyers are first-time home buyers looking to move to the area, so they're gonna have an FHA mortgage, which requires title insurance, so they have a whole MLI that's been done as part of that. It's also my understanding that the abutters do not object to the grant of this variance. But our request for the variance is based on the fact that there's been no adverse action contemplated by the town, to my knowledge. The only issue is this garage, which was placed where the town told them to place it. As a result of that, they're not able to sell this property for fair market value. And they have a home equity loan that has continuing monthly payments that they have to make, which they're not able to make unless they can sell this property. So they will suffer direct adverse harm if they're not able to obtain some form of relief from the town. We believe this meets all four of the requirements for a hardship waiver in your ordinance. Alternatively, we also are submitting the case of DeGrossier versus the City of Auburn, which deals with the issue of equitable estoppel. And that's a principle when, in response to a direct statement from a municipal officer, residents take action with respect to zoning compliance to their detriment based on a mistaken reading of an ordinance by the town official, that the town cannot then use that mistake to take enforcement action against the residents. So I've summarized that in my letter for you and given you a copy of the decision for you to consider. I realize one can't necessarily digest all of this right now, but perhaps in your continued deliberations, that may be useful for you. But I think we meet the test for a variance, but even if we don't, I think that's a pretty close match for the facts before here. That case also addresses uncertainty about the role that the municipal officer occupied at the time that the statements were made, in a footnote, I believe, on the first page. So the issue isn't so much whether or not the road commissioner was the right person to be ruling on the issue, or whether he acted outside of his authority normally in saying this. The point is, he was an official of the town who told them, you'll never be able to keep this property up if you build it here. And keep this garage up if you build it here. And so they went and they built it where he told them to. And so now they've been harmed as a result of that. That's essentially our argument. I'm happy to answer any questions. Eileen and Terry are here. They can help with the facts. I believe that the brokers are here, as well as the intending purchaser. Thank you.
Okay,
Yeah, so.
yes, I'd like to recognize Bill Simon.
Initial question is, everything is so well documented, I mean thoroughly documented, but there's one thing that's missing, and that is it's hearsay, and that is this road commissioner, or public works commissioner. Everything that's been said, done, whatever, is documented. So without hearing from this road commissioner or public works commissioner saying, indeed, he said what he said, or instructed what he instructed, or what was his rationale or reasoning for doing it, that's a big void in this argument.
May I respond to
From my
that?
point of view.
Yeah, I would just say that I don't believe we're under the formal rules of evidence in a hearing like this. And they're here testifying to what they heard and what they experienced, their direct impressions from the town, same representations, and those were also similar to the ones that were made in the DeGrossier case. So I would just say, if the town has competing evidence, we're happy to hear that.
I have a question.
Yes,
I've heard two things here. One is they're looking for a variance, then he just mentioned hardship. What is this?
well, the hardship is a requirement for the variance.
Oh, so
And
we
variances
are
are-
we doing a hardship or a variance?
Well, no, it's a variance is hardship. It's one of the criteria for approving a variance is hardship.
Okay.
And once we get to that point in the review, we're gonna look at those criteria that I believe Attorney Malloy mentioned, and we're going to look at them together to see if we believe that they meet those criteria. We're gonna go through them all once we get there.
Okay,
Yeah, but that's one of them is hardship. It's good, it's a good question. And that's not always so easy to, determine, well, what's a hardship and what's not, but I'm sure we'll have a good conversation about that when we get there.
I have a question.
Okay, Neil Berry.
So the drawing he initially submitted, was that correct?
I believe that met the 100, I guess you'd have to ask your code enforcement officer whether it was correct at the time, but
What, seems like it wouldn't be room to move for 50 feet between the garage and the boundary. He had 50 feet between the garage and the boundary
right.
on his drawing. So the code enforcement, the public works guy said.
So we
move
said
it
put it
back.
within 6 feet.
Oh. Okay,
He
but-
said line it up with the mailbox.
But at the
Just right
same
there.
time, the drawing shows 90 feet from the road, I believe. How far is it from the road in the drawing, or 50?
It says 9.
Nice.
It says 90,
feet.
yes.
Yeah,
So.
so it'd have been more
and the
than
code
50
office-
feet back, yeah.
Okay, so let's just take a step back. So the Public Works Director said at the site that it had to be 90 feet from the road. Is that correct?
No, he said that put it within 6 feet of the road.
Within 6 feet of the road?
He said put it where it is
I
now.
don't think so.
No.
Yeah.
Originally, we wanted the garage
Could you, sorry.
Yes.
Come on up here.
Come on up.
Originally, we wanted the
Just
garage.
introduce yourself
Oh.
first, just since you're on.
Terry
Yep.
Freed, I'm part owner of the property on 12 Rabbit Road. And originally, when we wanted the garage built, we wanted the front of the garage to be even with the front of the house.
Okay,
The front of the house is 75 feet from the center of the road.
okay,
And that's where we wanted the front of the garage.
yeah.
So when I came here, because I thought I needed a permit to put in a driveway, which later on he said I didn't need one, but anyway, they directed me to the town garage to talk to the road commissioner.
Uh-huh.
So when I got down there, I talked to him, and he says, well, where is it? And I says, it's at 12 Rabbit Road. He said, well, I'll follow you down there, and we'll take a look at it.
Yeah,
So he came down, he looked at it, he says, I want the driveway as close to the mailbox as you can get it, because that's the high part of the land, and he said he wanted to make sure that the water runoff would go away
as close as you can get it.
to the mailbox. Because
Okay.
the land there was like this, and both sides went down like this.
And then at that point, did you go to the town hall and submit your permit application?
The contractor put in for the permit for the garage.
And did that happen after you met with the,
I don't know.
okay.
I'm just telling you what I know.
But he said as close as possible.
As close as possible to the mailbox,
Uh-huh.
because it was on the high side of the front of the property.
What is most possible, the driveway or the garage?
The mailbox is the mailbox is on the high side of the property. In other words, where the mailbox is, the property goes like this. So he didn't want it down here because he said it would interfere with the water runoff, so he wanted it on the high side, which is about where we wanted it anyway. We had to move it over maybe 3 feet,
This is the driveway you're talking about?
the driveway.
Yeah.
So I says, okay, we can do that. He says, and I want the garage, the pad prep work for the garage, 90 feet from the center of the road. He's the one that said 90 feet.
Mm-hmm.
We wanted it 75. And if it would have been 15 feet closer to the road, it would have taken the back of the garage probably completely out of the setback zone.
What is the front setback in the district?
50 feet
50
from the
feet?
property line.
Okay, yeah, and is it a 3-rod road?
I'm not sure of the measurement of the road.
Rabbit Road, 3 rods or 4 rods?
I don't know.
Do we know?
I can't speak to that.
Okay, so I'm assuming it was probably 3 rods.
I don't even know what a rod is.
Approximately 16 feet.
I think it's 4.
Okay, well, if it were a 4-rod road, that'd be 50 feet.
It's at least
50
that.
plus 50 would be 100.
I don't
So-
believe, I don't believe Rabbit Road is that.
Wide, I don't think it
We
it
me-
is either. I think
me-
it's 3 rods.
I measured from the center of the road to the house, and it's 75 feet.
Yeah,
And that's where we wanted,
Okay.
that's where we wanted the
That was
garage.
the building.
right.
75 feet from the center.
When was your house built?
1999,
Mm-hmm,
finished
Yeah.
up about 2000, I think, it was right in that area.
okay, yeah, so,
Do you remember if the road, the Public Works, is it a Public Works or Road Commissioner that were?
We have Eileen come up, she might be helpful.
He said it was the road, they told me the road commissioner.
And did he give you a reason? Do you remember him saying why he didn't want it where you want it, but he wanted it 90 feet back?
He didn't give me a reason, but I figured, you know, he's the town
Okay.
official, he's telling me to back it off.
I'd like to slow things down here if we could, and if we could direct to Alan and ask Alan why the code enforcement officer would have said 90 feet. What his,
Code officer didn't.
or, no, I'm sorry, at Calvin, yeah, thank you.
I
Why
don't-
Calvin would have said 90 feet?
Yeah.
Don't know why.
What would you have said?
I would have said it needs to be 50 feet from the property line.
Okay, and if it's a 3-rod road, what would that make it?
I would look for pin, if they had pins, I would look at a pin.
Yeah.
Look at their pins and measure from the pins. If they
Okay.
didn't have pins, I would have to look at where I thought it would be. And
Yeah.
come some distance off the road.
Yeah.
And measure from there. And-
Okay.
And measure 50 feet, and I would always tell them, you should really put that 52 feet or 53 feet away from the setback, just to be
Okay.
sure. Because we don't know, if we
Now-
don't know where that is.
He said from center line. What is, Calvin said from center line, at 90 feet from center line.
That's what he said.
So what is half of a 3-rod road?
I don't know anything about rods, I don't know
Okay.
anything with roads.
All right,
Section 32 would be, what, 25 feet,
be about 25 feet. Yeah,
I think,
yeah, right, so it'd be about 75 feet.
right.
Okay,
So, 25 feet, there's a 20-foot right-of-way?
depending on the width of the
edge
road.
road,
Yeah, roughly,
20
Yeah.
feet?
Depending on the width of the road, yeah.
Yes,
Yeah.
okay. I think, and so now we're talking 40 feet.
So we don't know exactly, but it sounds like it was kind of a, wasn't an exact number. It may have been a more approximate number, the 90 feet.
So you
Something
take
else.
40 from 90 is 50 feet from the center of the road.
Yeah,
So, and what's the setback, 50?
50 feet from the property line.
I
So
gotta, I gotta say that probably that's where it should have been.
roughly 90, or we don't know
90
exactly.
from the center road
From the center
or
road.
50 feet from the property line,
Uh,
which would have been 90 feet less,
Right. So, we don't have, but, of course, as Alan noted, you know, the road isn't always in the center of the right-of-way,
exactly.
right?
We don't know the road
So we
within
don't know.
3 feet, one way or the
What
other.
I
Yeah.
would do today is, first off, I'd ask for a survey. If we
Right.
had the survey, we'd locate the pins.
Yeah.
And we'd measure the pins, and measure from where the pin said the property line is. That's where I'd measure the setback. And always say, if we're measuring 50 feet, I would suggest you go 52, 53 feet.
Right.
Before you put your building.
Yeah,
So that's the way I would do it. If there are no pins, and that's the way it is a lot of times, and you don't know where the property line is,
yeah,
you're gonna give it an estimate, and you're gonna err on the side of caution.
yeah,
Don't be into the setback.
yeah.
Don't encroach on your property of a neighbor, those things.
I have a question, Paul.
Okay, yes, Neil.
Do you remember when this conversation happened?
When?
Yeah.
Sometime in September, I think it's
19?
of, yes, 19, yeah.
And was the builder present for that conversation?
Not for that one.
Okay,
He gave me a name of a contractor to do the driveway, and I think he was present, because he knew the garage prep work had to be 90 feet from the center of the road.
okay. So, and at some point, the builder went to the code officer and submitted a permit application.
Right.
Okay.
He took care of that.
Okay. At any point, so you felt there was clarity in the application? Well, you know, I guess one of the things I struggle with here is that I'm not sure, could you build this garage the way it's represented on the building plan? I don't think you could. Could you?
Well, I'm thinking if the code officer said we could, then we could. That's what I'm,
Permit was issued,
yeah. He gave us a permit, I mean,
and we're acknowledging that it encroaches, so.
Okay.
I mean,
Just a question on the date. So the building permit application was submitted on August the 6th.
Was approved August the sixth.
Was approved. Well, I'm seeing the date of the application is the 6th, and I'm also seeing a permit was issued on August the 6th. So both seem to happen the same date. But then, but I think I heard you say that your discussion with the Public Works person was in September?
Yes.
So he would have suggested the change after the permit already stated that this was within the setback of 50 feet. So if he had said it had to be changed, wouldn't the permit have had to been updated?
Yes, I think this is an interesting question. If it became evident to the builder that it wasn't possible to build the property, you know, according to the plan and the permit, did the owner or the builder ever go back to the code enforcement officer and say, I need to revise my permit because this, you know, this
Nobody
doesn't work?
told us that it was in the setback zone. Nobody ever told us it's in the setback zone.
If,
And when I got the permit for the driveway in September, right, it was because he couldn't start the garage in August. So he gave me the name of a contractor. I got a contractor to come in and do the driveway.
But
It was in September.
if you're reducing the side setback and making it less than is on your site plan, wouldn't you go back to the code officer and ask, is this okay?
He had just told
Can
him.
I do this?
He had just told him where to put it and what to do.
He told us
you
where to
know,
put it,
So,
but.
Who told him?
the road
Road
commissioner.
commissioner.
Okay. The
So
road,
the
the
road
road
commissioner
commissioner
steps
doesn't
into the
issue
shoes.
building permits.
No, but he's a town official who is representing the town, and he's one telling him, you have to move it here or we'll tear this down.
Yeah.
And so they're responding to that representation of the town. He's not saying, you need to go back and revise your permit application. He's not saying,
Nope.
you know, this is what a setback, he's saying, put it there, or I'm gonna tear it down. So that's what they
Can I
did.
ask a question? Cheryl Haggerty, right here, listing agent. Did the code enforcement officer of the town of Durham ever make a site visit like it was supposed to?
I don't think I've seen.
Okay.
I didn't see him.
And I'll just repeat the question. Okay, thank you. No more questions for now until I think we open the public hearing or we have you come up, if that's possible. Just so we make sure we get everything
I'm actually
recorded.
not part of the public
Yeah.
hearing. Here.
Okay, very good. So the question was, and the question was from Linda Flaherty? Is that correct? I'm sorry, your last name?
Cheryl Haggerty.
Oh, Cheryl Haggerty, thank you. And the question was, did the code enforcement officer ever make an inspection or come to the property?
Right, I did read
Okay.
the town ordinance, and that is part of the job.
Okay, thank you. Thank you for that
Well,
question.
prevent things like this.
Okay, so, do we have any information on that, Alan? Whether the code officer ever made an inspection?
I wasn't here at that time, and I don't see.
Have you looked at the
notes.
record?
Yeah, I don't see any notes that said any date that he appeared on site.
Okay, thank you.
Can I just ask a question?
Sure.
I mean, I don't want to interrupt your train of thought, but we're acknowledging that there's a violation. I don't think the issue before the board is how a violation came about, other than the fact that they didn't cause it. You know, we acknowledge that it's within the setback requirements. The
Yep.
property is otherwise in conformity. And so at that point, for the question before you on a variance, I think it's appropriate to move to the hardship factors, rather than speculating on why the town was misrepresented or not. I mean, the fact is, you know, there's been a mistaken representation on behalf of the town,
Right.
which they then relied upon to their detriment. I acknowledge that it should have been caught, but it wasn't, and it's not the.
I understand.
Their, you know, it's
Yeah.
not their responsibility
Yeah.
to tick every box for the town that way.
I would, nevertheless, I would like to ask the question whether the builder or the applicant ever asked for an inspection.
Yeah,
The building?
Yes.
I don't know. He took care of the permit and, that's all I know. He said he'd take care of the permit and he came down and got the permit.
Okay.
Did he ask for an inspection? I don't know.
Typically, inspections aren't triggered until the builder calls and says, I'm ready for an
I
inspection.
can't speculate as to the town's
I
usual,
don't know.
practices on that, but.
Neil?
So I don't know when this drawing was submitted, if it was part of the application or not, but it has a 90-foot setback on the drawing, so I think the conversation with Calvin, if that's who it was, is irrelevant.
Yeah.
Myself.
Well,
And
okay.
I agree with Mr. Malloy, I think we should move on to the.
Yep, very good.
to the-
Okay. Let's see here.
oh,
Any other questions
Yes.
for the applicants?
Well, just
Before we move on,
As a point of interest, on the original application, there was also a 90-foot setback from the front. I don't know what that means. Property line setbacks, they had 90 feet on the application.
Yep.
That's
Yep.
90 feet from one.
I'm guessing it says it's from the center line,
Yeah.
but that's not what the ordinance reads.
Yeah. That's what the drawing shows too, so
Yeah.
that's at least consistent.
Okay. So before we move on to the criteria and the question of hardship, I think we should also hear, if there are any other comments from the public or from anyone else here this evening.
Sure.
We should
Yeah,
open the public
I
hearing.
think that some of the other interested parties would like to be heard, I believe, on hardship related to this. Eileen, do you want to speak anything more?
Yeah, we're gonna open, oh, yes, thank you.
Just,
Yeah.
Eileen, do you want to say anything more?
I think we've covered it.
Okay,
We've covered the financial. Unless you want my social.
thank you, Will.
Thank you. Okay, well, with that, if I could just have a motion and a second to open the public hearing.
I'll make that motion.
Okay, in a second,
I'll second it.
discussion? All those in favor? All right, so let the record show, that was Milton Terry, right? All right, the public hearing is now open at 6:48. And do we have anyone here anyone else that would like to speak? Please come up and state your name if you would, and who you are or where you live.
Hi, Cheryl Haggerty, and I'm here representing the sellers. And I just want to vouch for, if you guys don't give them this variance, they really are going to have a hardship. Number one, the buyers are going to be pretty much homeless. And as you can see, it wasn't something they did intentionally. Yeah, I don't know who's to blame 100%, but it's happened. So without the variance, they can't move forward with the sale, and it's been prolonged for so long. We have some things that need to get done before the sale is consummated, like like a roof and stuff like that. But they'll definitely, so they have a payment on the house that's vacant. They're in a different house, and so they don't have a lot of extra money to make the payment. So I don't know what's gonna happen. And not everybody wants to be a landlord. I guess that could be a possibility, but, they really need the money out of the house.
Yep.
So the bottom line is how, and I know what you guys are thinking, you're on this committee and you don't want to give variances. You want to do it very minimally because you don't want everybody and their brother coming here and doing this. But I do feel like, Mr. Malloy says they do meet the hardship requirements, and it's unfortunate that, we have to come here and ask for this, but we are all human too, and we do have to have some compassion in these situations. And I'm hoping that you guys can have that for them. I mean, because it's not really gonna hurt anybody at this point. The neighbors are okay with it, and it's, what's it gonna do? What is it gonna do to detriment the town to just, give the variance? We did try to get the consent agreement instead, which, when I read the ordinance, it looked like that was the way to go, but, you guys don't wanna do that, the select board doesn't wanna do that, so this is why we're here, and I'm just hoping you guys have some compassion in the situation, okay? Thank
Thank
you.
Okay, thank you. Is there anyone else who'd like to speak?
having some trouble with the connection. Please try again.
Sorry. Okay. Yeah, Siri, you're not recognized.
My name's Tyler Stewart. I represent the buyers in this transaction, and I just want to let the record show and just make one final point to the fact that the buyers have already signed a rate lock extension at the expense to them because of the delay of this transaction, given not only the process, but also the failure to meet at the last meeting. On top of that, to Cheryl's point, we have continued work that needs to be done that we can't start or are waiting to start until after we get this figured out. Their current rate lock extension expires on the 22nd. So they will need to sign another one as well, which will be another expense to the buyers. So not only is it a financial burden to the sellers, it's also to the buyers as well, because they've had to pay thousands of dollars in fees to extend this process longer than typical. So, just wanted to make that.
I'm sorry, did you state your name for the record? I may have missed it.
Tyler Stewart,
Tyler Stewart.
Yep.
Thank you. Okay.
buyer's broker.
Yeah, got that, thank you. Okay, is there anyone else here this evening that would like to speak? All right, then let's move on. So,
You can close the hearing.
yeah, I'll go ahead and close the hearing. I don't think I even really need a motion to close it. And I will close the hearing at 6:52. All right, let's move on. Okay, so, let's take a few moments here, see where we're at. All right, so, further questions for either our code officer or the applicant? Does anyone have any further questions at this point?
I have a question.
Yeah.
Even though the contractor drew the building permit, Alan, is not the owner of the property still responsible?
Ultimately, the property owner is the responsible party, even if they hire a contractor.
The contractor's working as their agent. And I think in this case, without even seeing a contract, I would say the contractor built the garage and that's accepted. So the contractor is the owner's agent. Would you agree with that?
Yes.
Yeah. Okay, it was a good question. Other questions?
Question for Alan, is there an option available to move the garage?
I'm sure properties can be moved, I know houses can be moved. So if it's a current, although it's a garage, it's
It's on a floating slab.
It's a little tougher, but probably a mover could do that. I'm not sure. I don't know if they've projected to that.
I remember a while back Connie
Yeah.
Footman, I don't know if you remember Connie Footman.
I think she may have been before my time.
She was the mother of the town, came
Okay.
to us because her garage didn't meet the setbacks.
Okay,
And the appeal board turned her down and suggested that she get a hold of the abutter
yeah.
and buy 10 feet of land.
Abutter transactions aren't subject to subdivision law.
Right.
Yeah.
Okay, and that's what she did, and then on, she was okay.
Uh-huh. Okay. Yep.
You know, to meet the setback.
How long ago was that? I'm curious.
It was a while back.
Yep, okay.
I remember, I've been on the appeal board a long time. but
Yeah,
I-
we're lucky to have you.
Right, yeah.
Okay, thank you. I appreciate that, Terry. Other questions from either Neil or from Byron?
I think I'm fine.
Would a code enforcement officer typically take a look at the drawing submitted on something like this and confirm it?
Typically then, probably not. Typically in 2023, absolutely, I would check grade stakes. this kind of thing comes up routine. But then again, I do wanna put out there, I'm standing there may not be a property line that I can see.
Yeah.
There may be stakes, that's great. If there's a survey, yay, good, awesome. But I'm gonna make my best estimate, but I'm gonna tell them also, this is only my best estimate based on what I can see. I'm not an authority in this situation because I don't know where that property line is. So you are ultimately responsible. So the best way to check it, lots of times when I check for shoreline zoning, measure shoreline zoning, people want me to do it because the town pays me. But I'm not an authority on that. I will check that property line, but I'll have them check in shoreline zoning and say, I asked the code officer what we should do, and he said I should get a surveyor to delineate the shoreline zone. But we wanted to use the code officer's opinion instead, and I am not an expert in that. I will do that for you, but I'm not the expert, and you are the person ultimately responsible. If DEP finds those kind of things out, you are the person responsible. I'm not responsible.
So if you are doing something in the land use ordinance where you don't have to go to the planning board, is there a survey requirement?
No. So lots of people don't
And
have
so
surveys.
if there's no survey requirement, you'll say, put grade stakes where the line is, where you think the line is.
I'm gonna tell people to talk to their neighbor and come to an agreement where they think that property line is, and we're gonna go from there.
Okay,
Not a great situation.
yeah, okay, thank you. All right, so additional questions? Okay. All right, very good. So, why don't we move on to the criteria, the variance approval criteria in the ordinance? Does everyone think we're to that point to look at the ordinance?
Yes.
Okay. Let's do it.
Would you like me to read them?
I've got 'em. Yeah, Neil, if you would. If you would start with and read, starting with B on page 158.
Dimensional variance. The Board of Appeals shall not grant a variance from dimensional requirements unless it finds that A, the proposed structure or use would meet the performance standards of the ordinance except for the specific provision which has created the nonconformity and from which relief is sought, and
Okay, hold on. Hold on one second. Just- Okay, yep, okay, go ahead.
so everything's okay except for the nonconformity. That's what that's stating to us.
Okay, yep, okay.
The strict application of the terms of the ordinance to the petitioner and the petitioner's property would cause undue hardship. The term undue hardship is used in this subsection means the land in the land in question cannot yield a reasonable return unless.
Question,
Yes, let's stop right there. All right.
do we need to go any further than what he just read on dimensional variance?
Yes.
Yes, we do. We have to apply these four criteria in the ordinance that he's going to read out. We're gonna go through them one by one, I think, and try to come to some
Even though it says
conclusion.
we can't grant the variance?
We can grant a variance.
What's that?
We can grant the variance.
No, I think we can if it meets the criteria.
Board of Appeals shall not grant a variance from the dimension required unless it finds that.
Shall not grant a variance from dimensional requirements unless it finds that, right. Okay, so let's look at A first. The proposed structure or use would meet the performance standards of this ordinance except for the specific provision which has created the nonconformity from which relief is sought. Okay, let's ask the code officer. Is this property otherwise compliant?
Yes.
Thank you. all right, so I think A is met,
Right.
so let's move on to B.
The strict application of the terms of this ordinance to the petitioner and the petitioner's property would cause undue hardship. The term undue hardship as used in this subsection means the land in question cannot yield a reasonable return unless a variance is granted.
Okay, stop right there. The land in question, again, these are 4 tests for undue hardship. Now, my interpretation of the ordinance is that it has to meet all 4 tests.
That,
And is everyone on that same page?
yes.
Okay, because it
Subject
says
to-
unless.
Subject to individual interpretation.
Okay, what do you think?
I agree, yeah.
Okay, good. All right, very good. So, number 1, all right, the land in question cannot yield a reasonable return unless a variance is granted. Okay, so under hardship, yeah, I'll put that for discussion. Does this, can this land, yield a reasonable return if it's not granted?
Are we discussing this over there?
Yes,
Yeah, okay.
I think so, yeah.
So reasonable is subjective.
Yeah, okay,
In my opinion, they meet this,
yeah, okay, very good. Yes. Reasonable return.
I'm saying they would not get a reasonable return.
Unless a variance is
unless the variance
granted.
is granted.
Yep, very good. Okay, Terry?
Yeah,
Bill?
I can accept that, yeah.
Okay, very good.
Yep.
Bill, okay, I would concur with you folks. Yeah. They're trying to sell, it's reasonable to be able to sell your property, I would think. Yeah.
Well, I'm sure the value of the property right now includes the garage.
Okay. So, Neil, what do we have next? So it seems to meet number 1.
Yeah.
Seems to
2,
be some
the
consensus.
need for variance is due to the unique circumstances of the property and not to the general conditions in the neighborhood. And.
Okay, the need for the variance is due to the unique circumstances of the property and not to the general conditions in the neighborhood.
So my take on this is a lot of unique circumstances.
Yeah.
I couldn't, we repeat that?
There's a lot of unique circumstances in here. And I'm inclined to support the appellant, what they're looking for.
Okay, well, let's take it one at a time if we
The
could.
general conditions
So
of the
what,
neighborhood have nothing to do with it.
tell me about the lot. What's unique about the lot?
I don't know there's a whole lot unique about the lot, except obviously that,
Well, let's look at the lot plan for the mortgage loan inspection. Okay? And see what the lot looks like.
what might be unique about the lot is where they wanted to put the garage in terms of the setback.
It's kind of pie-shaped there where they wanted to put the garage.
The setback requirement may have excluded the ability to meet the setback requirement from the rear.
Where they want to put the garage, it doesn't look to me like you possibly could do all those things. Like you could meet all those setback requirements in the permit. But, so I would say what's unique about the lot, I mean, it looks to me like what's unique about the lot is it's this kind of wedge-shaped triangle. So it, it's kind of narrow on the sides there where the buildings are currently.
Is your front door on that side of the garage? Oh, I'm sorry, I should be addressing you.
Oh, that's okay.
Is your front door on the side of the garage?
Front door?
The front door when you,
Faces Rabbit Road.
so it's convenient for you to get out of your garage and walk into your house where the door is now.
Yes.
Yes, that's why the garage went there. Yeah, but you got it, okay. So the garage went on that end because that's how the house is oriented. Yeah. Okay. Okay, great. Let's move on to number 3.
Did we vote on that?
Well, I don't think we have to vote on these individually necessarily. I mean, of course we could, but I'm happy with consensus and a bottom line vote on the variance. I think that's usually the way we approach it. without getting too much into minutia, I think we're getting what we need. So, yeah, what do you guys, but we haven't heard from you guys. So, I mean, personally, I would agree, I think the lot has some unique characteristics that could support number 2. So I would be a yes on number 2.
Okay.
Are you a yes on number 2? Okay, so, Milton Terry,
Yeah.
okay?
I'm not sure.
Okay. Okay, so we've got one uncertain. Okay. All right, let's go down to number 3. The granting of a variance will not alter the essential character of the locality. You know, of course, we haven't had a site visit, haven't done a site visit or something like that, but I think this is, if I'm not mistaken,
I
you know,
drive by there all the time.
okay, this is a general,
Not gonna change.
yeah, I drive by that area too. It's a, you know, it's kind of your average Durham neighborhood, I would say. And rural residential, it's zoned rural residential, lots are 2 acres plus. There was a letter from the abutter, who said that they wouldn't object to a variance. At least on that lot line. So, you know,
Just-
again, we're talking 20, from 20, which is the ordinance, to 6. So it's 14, a difference of 14 feet.
When discussing number 3, not altering the essential character of the locality, do we need to anticipate setting precedents?
I think it's a case-by-case basis. I think, you know, you have to evaluate each case on the merits. Is there any kind of buffer? I'll have to ask, is there any kind of buffer between the garage and the property line? Is it vegetated or is it cleared? What's it vegetated with?
Trees.
Okay.
Trees, bushes.
Okay.
Well, if you move the garage forward, it's gonna,
Well, if you read
it's gonna,
136, a lot of the homes down there, they bang it down and just piles up.
Okay. So,
if you move the garage forward, it's gonna have the same character it has now.
okay.
You'll see it.
Yeah, okay, so if you moved it forward, right, because that's what you would have to do.
But it never bothered us.
Yeah, but the challenge is, I think if you move it forward, if you were to move it forward 14 feet, it may violate the front setback. That's kind of the conundrum.
Maybe, you don't know.
Maybe,
But my argument's still the same.
Yeah.
It wouldn't change the character.
what do you guys think? Would it change the character?
I don't know.
Okay. Yep. That's fair enough. Yeah.
It doesn't, you know, that word character is subjective, it goes against what it states in the ordinance.
Well, that's my feeling.
I don't think it was referring to the ordinance, it's referring to the character of the town and the locale.
It's a rural, you know, we're a rural community. We have a lot of 2-acre lots. We have a lot of larger lots, you know.
But they were
We-
grandfathered.
We have smaller lots, too. You know, we have some lots that are significantly less than 2 acres. That kind of a mix. What do you think, Alan? I mean, you know, you get out there, you see this town, you visit a lot of different properties. I'm just kind of curious, you know, of course, you know, you don't, have a vote in this, but where, what do you see in terms of?
There are other properties that are grandfathered, as you just mentioned, that do not violate the setback because they're grandfathered.
Right, okay,
So there are other houses that have similar situations like this.
yeah,
Not identical, but similar.
fair enough. Okay. Okay, so it sounds like, now what I'm hearing from Terry and from Milt is that you guys are a little on the fence, you're not sure on the character piece?
No, I'm not, no.
Okay. Okay.
You think
So,
removing the garage is gonna change, is gonna fix the character of the location?
It's, I'm a great one for the rules. The rules are 20 feet, cake covered.
This isn't talking about the rules. This isn't talking about the rules, it's talking about the character of the land and the neighborhood.
Well, I think if we start setting precedents here, we're gonna be in trouble. If we let 6 feet, if we let 14 feet go here today,
well, let's, I think what's important is that we let the ordinance guide us. And we've got some criteria in the ordinance, and we're not all the way through them. So I'm trying to keep an open mind until I get to the end.
okay?
Yeah.
So the word character is kind of a broad word, and to address Neil, so whoever wrote the ordinance and came up with the setbacks, they had character in mind. They had character of the location in mind, and that's why they came up with whatever setbacks they came up with, so.
What's the district? What's the zoning district? Sorry to interrupt, but what's the zoning district? Rural residential, right?
Right, but dimensions were established for a rural district.
Right,
And
right,
the ordinance
okay.
was written.
Yep,
So, someone came up with that it needed to be, well, no matter what the number was, 20 feet, 50 feet, whatever those numbers were, when whoever came up with the numbers of what those setbacks or placements or whatever, they had character
in mind.
in mind
Yeah.
for rural. So so I'm just playing devil's advocate. So when you say it's not affecting the character, well, if we were to go back in time for those who set up those guidelines, they might say, well, you are changing the character, because otherwise we would have said, 6 feet was good enough, or 10 feet, or whatever, but they came up with specific numbers. They had discussion, there was logic behind those numbers.
Well, your thinking is good, but it's wrong, because the wording comes from state law. It's just a state ordinance, state law, it's not a municipal ordinance, it's a state law that we adopted. So they weren't thinking about.
In terms of the criteria, the definition of
Yeah,
undue
it's
hardship.
right in
Yeah.
MRS 4353, whatever it is.
Okay, yeah.
It's not a town ordinance, it's a state law.
Well, no, but not the setbacks. He's saying the setbacks were, so
Right.
part of it is, part of it's
The
not.
town established the setbacks, didn't they?
Yeah.
Yeah, but the thinking of it, the thinking of essential character is not specifically regarding setbacks. It's to me, the whole picture, the big picture of the neighborhood.
Yeah. Okay, well, again, this is, I think, as Milt said, character is subjective. And, I'm not even gonna look to see if it's defined in ordinance, because I know it's not.
I just looked up the definition of character.
Oh, and,
That's related to neighborhood.
okay, yeah, go ahead.
Neighborhood character is an amalgam of various elements that give a neighborhood its distinct personality.
Mm-hmm, okay. Yeah. I think on this one, I appreciate all perspectives on this, and I in all interpretations, because I think it is highly subjective. But I'm not gonna draw, I guess I personally, I'm not gonna draw the line on this one. I think it's probably close enough. Okay, do you have a thought, Myron?
Just one thought about character in this application. To me, when I hear that being said, it's more of, you don't put a high rise in this
Uh-huh.
neighborhood, or you don't come into a place where we've built a certain style of homes
Yeah.
and then put in something that is radically different. You don't put an igloo next to, all these
An
regular
igloo.
homes, or like I said, a high rise or something
Yeah,
like
yeah.
that. That to me is character,
Yeah,
Like they did in Boy Hill subdivision.
yeah.
all right, careful now.
So that was just my thought about character.
Yeah, thank you, that's helpful. Yeah, okay. All right.
Am I allowed to make a point here?
Public hearing is closed, but, anyone have an objection?
To
Okay,
what?
to a point from, and I'm sorry, you're the buyer?
Yes,
Yeah, okay. Any objections to hearing from the buyer at this point? But I don't have an objection. Okay, please, if you could just say your name.
Yes. My name is Benjamin Roach, one of the buyers.
I'm sorry, Benjamin, and last
Benjamin
name?
Roach,
Roach.
R-O-A-C-H.
Okay,
My only point on this character concern is you're saying that they set up the ordinances taking character into mind. That doesn't totally make sense to me because this is to get a variance on those ordinances. So the character, I believe, is something considered separate from that.
okay.
As they're saying the feel of the land, because it's specifically referring to getting something corrected in violation of that.
Okay,
So I
Yeah.
don't think considering the ordinances as far as the character makes sense in this case.
okay.
So that was just my
Great.
point that I would like to make.
Yeah, thank you for adding that, we appreciate that. Okay. So, yeah, and these situations are never easy to resolve, and that's why we're all here. And I think everyone, I think I speak for everyone when I say that it really helps to hear from all the different parties and take it all in before we make a decision. So thank you for your comments. Okay, Neil, I think that we have, where we are on that is we have one no, we have one I'm not sure, and we have two yeses. Okay. Yeah. All right, so let's move on down to 4, Neil, if you could read that for us.
The hardship is not the result of an action taken by the applicant or prior owner.
Okay.
May I?
Yeah.
I believe on this one, the applicant or prior owner basically created the hardship.
Okay.
And that's why I asked the question earlier of Alan, who was responsible for the permit, okay? And the owners, it was stated that the owners are basically the liable for the permit.
Oh, even though it was signed by the builder, or it was taken out by the builder?
Even though it was drawn by
Smart.
Home
Yeah.
Improvement.
Okay, yeah.
That's why I asked that question.
The builder was acting as an agent of the owner.
Yes.
Yeah. Okay. Okay. Milt, what do you think on this one?
The owner, it was not the owner's action, I don't blame the owner. But as Terry said, the agent acted on behalf of the owner. And so that holds the agent the owner responsible. Now, I can see, I know the owner's point, I mean, I can put myself in that same position. You put your trust in someone who, this is what they do for a living, and they say, you know, you're good to go, so you believe that they're good to go, and then, you know, you get haunted years later by mistakes that weren't their fault. But it's hard. I don't see why the permit would not have been updated. If the permitting all happened in August, and then this town official, you know, said, you know, you can't do that, and said this in September, again, to Mr. Malloy's point that, my earlier argument, but what would it have been, you know, so what if it had been a town clerk or the fire chief or who, anyone could have said, nah, don't do that, you know, well, I'm gonna do something. Nothing, it has to be documented.
In the permit.
Everything we do is documented.
So, to revise a permit, how does that happen? How does the permit get revised?
You go to the code enforcement officer and say, look, we got a problem, this is what we gotta do.
Or I go, or you, there's a meeting of the minds and you say,
Meeting of minds.
you know, you get the code enforcement and said, this guy says it's not okay, and this guy says it is okay, and this guy says I can do it either way. What should I do?
Yeah.
Is what I would be doing as an owner. I've just heard 3 points of views. So and I don't mean this personally, I'm just trying to stay as neutral as I can, I'm only supposed to deal with the facts. The owner should say, you know, that shouldn't just say, pick, when he has 3 points of views. One person says you can do it, one person says you can't do it, and the third person says, I'll do whatever you want.
Mm-hmm.
The owner has to make a decision based on, you know, not what's the most convenient, or what works for them the most. I mean, this is tough, but
Maybe there's a question of who has ultimate responsibility for the permit.
Yeah. I can see too, but,
I have a question, you know, just based on that conversation, I don't disagree with a lot of what you said, but I think as much as, yes, if you're the owner of a property, obviously you need to make sure you do your due diligence when you're doing these things. I also think when you're a town official, I don't care if you're the road commissioner or the code enforcement officer or the town clerk, if you're telling somebody that they cannot do something that isn't in your purview necessarily, or even if it is in your purview, don't you have a responsibility to follow up on it? Don't you have a responsibility to go back to the code enforcement officer if you're the road commissioner and say, hey, I just went down to this isn't gonna work?
I know, I would think if the owner just heard a different point of view, if he got one person to say yes, he's got it documented saying you are good to go. It seems to me I'd be going with what my document says.
They did go with what the
They
document
did.
said.
It did go by the document.
I think the Calvin conversation, and I'm not saying what didn't happen, but I think it's irrelevant. The document says 90 feet.
It does.
What they submitted was 90 feet.
But it also shows, setback.
It's incorrect.
Hold on. It shows a side setback of, what does it show on the document?
well, on the application showing 50 feet setback, and on the plan,
No, it says
it's
90
showing,
I think it's 2 different places. I think it says on the application, I think it says 50 and 90, right? I saw somewhere on one of the
Right, it
applications.
says 90 on the front and
Yeah.
50 left and back.
50 left and back, okay. Yeah,
So the back was wrong.
It's impossible.
The back was wrong,
It's
and
impossible.
I would have thought the guy who signed it should have some responsibility there. But so again, I think Calvin's conversation is irrelevant, because the drawing was correct, or is what they did. And what was wrong was the back, the back dimension.
okay, but how can you say the drawing is what they did if the back dimension is wrong? So it's what they did it's what they did in one regard, but not in the other.
In compliance with what Calvin said, which again, I think is irrelevant, they
Okay.
did, that met that, what Calvin said.
Uh-huh.
Whether he said it or not, it's irrelevant to me. The drawing said 90 feet from the center of the road, which is what they supposedly had to have. So they had to have that, and they couldn't meet the setback requirement.
We don't know if that's what they were told they had to have, again, aside from Calvin,
That's what they submitted.
but we know it's what they submitted. Yeah. Okay.
So if they submitted that with the dimension of the garage, they couldn't have met the setback. And I think the town should have some responsibility there to pick that up. Which is why I think it's not solely, at least solely, the applicant's error.
Okay, very good. So not solely the applicant's error, let's get down to some more specifics here. Where are you on number 4?
I don't think the hardship is a result of the applicant's action.
Okay. All right. So it's almost kind of like a balance here, like I'm seeing, so not solely, so you think it's more of the town's responsibility than the applicant's?
Yeah.
Uh-huh, okay, yeah. Fair enough. And,
So let me just repeat what you just said, in my words. So, we're disregarding any input from Calvin. We're just going with what the documentation says. The documentation says that the garage needs to be have a 90-foot setback from the front. And does this garage have a 90-foot setback from the front?
I think it does, or from the center line, from the front to the center line, right? Yeah.
From 75 feet to 90.
Yeah. But when that happened, it pushed it up against the sideline.
Yeah. So, they got the, Alan, who would have made these measurements for the setback? With the person who applied for the permit?
Yes.
And that was the builder?
Whomever, could be the owner, builder, likely the owner of the building. Submit the building
Who is Leroy Smart?
from Smart Builders.
Okay. Some,
Smart Home Improvements Inc.
okay.
Oh, yes, I'm
So the
sorry.
point you're making, Neil, is that when he submitted this permit application, it was stated that the setback was 90 feet from the front, which was correct. It was also stated it was 50 feet from the back, which was incorrect. Okay. And that's why we're here today, because it's not in compliance with the setback in the back.
The plan didn't work. The plan that was submitted doesn't work on that lot. That's bottom line, right?
Correct.
You can't do it. Yeah.
In looking at this piece here, and I don't know what this is, what is this?
That's the back page of the building application.
Okay, it says right here, it says, all drawings must be to scale or have detailed dimensions. Okay, I mean, it's in black and white, I mean.
Yeah.
And up here is a signature of owner or applicant Leroy Smart. on 7/30/19. Now, I got to be real honest with you, what I see here, for this isn't even close.
Yeah, yeah.
Well, it has some detailed dimensions on there.
Say what?
It has some detailed dimensions on there.
But the shape, you know, we're not dealing with the square, we're dealing with a triangle, for one thing.
Not to argue with you, but it says, to scale or have detailed dimension. Well, we already know that it's 6 feet instead of 50.
We know the dimensions are wrong,
The detail,
Exactly.
right?
the
The
detail is
dimensions
wrong.
are wrong,
So
yeah.
this is why I'm saying that somebody applied for it with the bad figures and they knew they were there.
Well, we don't, yeah, well, we know they applied for it, and we know they, you know, they
Were wrong.
signed it.
They
We
were
know they
wrong.
signed it,
So,
yeah.
But is that the owner's fault?
well, I asked the question, who's in charge of that permit? And I was informed that, it is ultimately the owner's responsibility.
And the
How,
town,
yeah, how would they know?
and the town.
Well, isn't it their job to submit accurate information? The owner's job to submit accurate information in their building permit?
But if this was submitted to the town and the town issued the permit, then the town accepted it as being adequate.
Right.
But, you know, it's interesting because what I struggle with is how is at that point when a permit application is submitted, how's the code officer supposed to know whether or not it's accurate? At that point when it's submitted, right? They can't, they don't know.
You basically
At
have to
that
take the
point.
word
You-
of people giving it. to
You have to take the word of the
You
people
do,
who's giving it
that's
to you.
supposed to be accurate information, you take the word at that moment.
Yeah,
Right.
but then you verify later,
You
that's
would
the,
verify later.
yeah.
At what point?
Now I verify.
You verify to the best of your ability, right? Because you
Yes.
can't, you're not a surveyor.
Correct.
Right, and you, even if, you know, you verify, you're taking the word of the applicant with regard to where the line is.
Mhm.
Yeah. All right. Yeah,
I have a point of clarification.
okay, why don't you come back up? Yeah. And again, state your name for the record.
Again, my name is Benjamin Roach, one of the buyers.
Benjamin Roach. Yeah.
Y'all are arguing over whether or not the 50-foot is correct. I believe the violation point is the corner of this garage, and this line goes at an angle across here. So those 50 feet measurements could be correct from the back of the garage to the property line, and from the
That's
side of the garage to
interesting.
the property line.
Yeah, but that's true, but a builder, it's their responsibility when they put that dimension on there, to put the dimension from the point of the building that's closest to the property line. Regardless, that's just standard convention for builders.
Yes, I just wanted a clarification on the
Yep, that's-
50-foot measurements.
Yeah, that's an interesting point, though, yeah.
Just to say, those 50-foot measurements might not be wrong that are in the drawing.
I don't know, yeah, I don't know if that's interesting. Yep, thank you.
So,
Yep. Okay. So, other comments with regard to number 4?
So I have a question.
Yeah,
So is part of the building in compliance and part of it's not? Is that what you're saying?
Yes, just the back corner,
The very back corner.
just the very back corner. So
Uh-huh.
when it went back,
if it's the back corner of the building's out of compliance, right?
It is out of.
Yeah, okay.
that's not
Yeah.
what he asked, he asked if the whole building was
Right.
out or what. We said,
Okay.
no, just the back corner.
Okay, so, other comments on 4 before we move on?
just the.
And I'm sorry, but I think at this point, I'd like to keep it, or I'd like to ask these board members who are faced with this decision, whether they have additional comments regarding number 4.
So, the dilemma for me is, the owner, the actual owner, did not cause this. It was not their action. So I don't hold the owner at fault. But the builder was the agent for the owner, where I'm stuck on is, and, you know, again, I can put myself in this position and just be ripping my hair out. But we're supposed to not have any feelings. We're supposed to be the most insensitive board in this town.
Well, yeah, I think you bring up a good point, and, you know, I kind of look at the history of this board, and I think it's important that we're not insensitive, you know, and we try to be wherever possible, to be, you know, how should I say, good neighbors too, and.
I
you know,
agree with that.
And compassionate, but at the same time, we have to operate within what we believe is the legal framework.
Right.
Yeah.
And we've always counted on, you know, a lawyer on the committee
Yes.
to help in certain things.
Yeah, very
So
wise
that,
ones.
and I would want a lawyer's point of view, so I'm missing our chair, because it's that question of, is the agent, you know, the agent is acting on behalf of the owner. And if the agent error if the error is on part of the agent, does
Yep.
it mean that the error is on the owner? That's where I'm stuck.
Yeah, well, I think, you know, maybe, again, I'm not an attorney, but I know my own personal view of that would be that, you know, if it's your agent, then they're acting on your behalf. And that, you know, you have told them they can, you know, whether it's a contract or whether it's a shake of hand, but they have agreed to apply for the building permit on your behalf.
Let's
Yeah.
do another scenario. So, let's say, I did something and I was acting on my attorney's advice,
Uh-huh.
and that advice proved to be wrong, proved to be faulty advice. Am I at fault, or is my attorney?
Well, there's another agent, there's another piece of that puzzle, is the town that accepted the application. So
Right.
You're missing a piece of.
I understand.
But he's only talking about this other piece. You know, but again, this isn't a court of law. You know, it's not like, you know, they're here because they committed a crime. They're here for, and of course they haven't. And they're here because they're asking for a variance. So I'm not sure. I think it might be a little personally, I think it might be a little apples and oranges. But I understand it is a little, you know, there's certainly some challenges here, but I go back to, you know, was this person the applicant's agent? And personally, I believe they were the applicant's agent because they built the garage and they came for the permit and they signed it. And I guess I would ask the applicant, did the contractor have permission to come from you to come? Was that the expectation that the contractor would apply for the permit? Or I would ask the attorney.
Are we gathering more information right now? Because it's so.
Oh, that's fine, yeah, we don't have to, I withdraw my question.
Yeah.
Yeah, okay. Yeah. So, yeah. Okay, so I think at this point, you know, we've kind of hashed this out. So I think and we've gotten a sense of where we all stand, I think, for these different criteria points. Is there further discussion that we want to have before we entertain motions? Yeah, Alan?
Can I just bring up about voting and what needs to happen?
Absolutely.
For the vote?
Yeah.
So voting, section 17.5, decisions on any matter before the board shall require the affirmative vote of a majority of the membership at the meeting or hearing, but not less than 3 affirmative votes.
Okay. Yeah, and of course, we are a committee of 4. So, uh,
I have a question.
Yeah.
that Maybe you can answer. Can you, have this gentleman who's an alternate be a part of the vote?
No.
Or not?
we cannot.
Not at all.
Yeah. We cannot, and, I think we already stretched that a bit by having the alternate participate in the discussion, but I think it's very valuable, because the whole idea of having the alternate here is that they, get some training and they become good appeals board members, and that's why we let the alternates ask questions. Okay, so, all right, that said, the options here are, let's just put the options on the table. The options are to deny, or to approve. And I believe, and I'd have to look at the ordinance again to recall exactly, but we probably even have the ability to deny or approve with conditions, or to approve with conditions. And the other piece of that, the other piece here is when we write the decision, we have to have specific findings. So I think it's important that if someone is ready to make a motion, that I would also like to hear, and I think we've developed some of those findings in the discussion on the hardship points. But I think, if a motion needs to include some specifics with regard to reasoning.
Mr. Chair, will we have a chance just to make any sort of summary argument before you?
Absolutely. I think
Okay.
that's a really good point.
Okay.
Thank you. Mr.
Well, now
Mr.
we
Malloy,
are-
come on up, or Attorney Malloy. Yes, Terry.
If I understand this, in all the years I've been here, 1 through 4 have to have all positive vote or negative vote or voted up or down. as a-
Okay.
As a unit.
Yes, thank you. So it's basically, my understanding of how it works is if you agree that it meets all 4, then that's a thumbs up for approval.
Exactly.
Exactly. So if you feel that it only meets 3, then that would be a denial.
Exactly.
It's that simple.
But that's why I think a vote is required on all of these
Uh-huh.
to get to
I think
the
that you
final
could,
vote.
I think that you could include your reasoning with regard to why it meets each of the 4.
Yep.
Or we could do a vote on each. I'm fine either way. But let's give a chance to Attorney Malloy to make his closing statements, and then we'll move on.
Thank you, Mr. Chair, and thanks all for wrestling with these issues. They are never easy, and that's part of why we have variances as a tool. These are here to sort of be the conscience of the town on an issue. By granting this variance, you are not opening the floodgates to every other application. That would be a wholesale rezoning, and that is not allowed under your ordinances, and it's not allowed under state law. But what your ordinances and the state law both provide is an avenue for where mistakes happen that were not anyone's fault, to bring some mercy to the situation so that people are not out in the cold. And I wanted to just say here, that goes to the issue of the setbacks issue. It's not, the issue is not whether or not granting a variance is gonna alter the setbacks. That's somewhat respectfully beside the point. The issue here is looking right at each of these factors. In listening to you speak tonight, and I applaud you for going through them in the analytical manner you did, what I heard was that Part A here, in terms of the violations being limited to the setback issue, was met. And then when we got to the hardship issue, it appeared that there was unanimity on at least the first 2 of the hardship issues there. I'm not sure where we ended up on point 3 in terms of the essential character of the locality, but that's where, again, I go to the essential character is one of the essence, the qualities. This is not somebody putting a slaughterhouse in a residential neighborhood or a a high-rise or something that is going to change the nature of the town of Durham. It is still a residential community. It is still a residential neighborhood. It just has a garage that one corner of it is within 6 feet of a property line. And we acknowledge that, okay? But that's what we're here to say, is by doing that, does that so change the nature of this neighborhood, of this community, that it's unacceptable to this board in this one particular circumstance? Finally, we turn to that issue of the action taken by the applicant or the prior owner. And I appreciate the struggle to deal with this concept of agency, but when I look at the text of this ordinance, I don't see the word agent anywhere in there. And I think you're reading into this and in trying to grasp with this, perhaps out of some anxiety that this would be opening the floodgates. And, you know, if the builder goofed, then shame on him, but not shame on Eileen and Terry, who trusted people, and then had a town official come and tell them something contrary to what the ordinance said. The other point here is, I think we've been wrestling with some historical shortcomings in how the town has done its paperwork. And again, you know, I realize Mr. Plummer here tonight is not the one responsible for that, and it sounds like he's being very diligent in his duties, and we're very appreciative for that and his efforts. But again, is the right solution in this request to make Terry and Eileen responsible for whatever shortcomings the town had in following up on its paperwork, in closing permits and following this up? This was not them erecting, you know, a high-rise or putting in a slaughterhouse or taking something in open defiance upon the town's requests. They did exactly what the town told them to do. And so I would ask that you really take that into account for a couple who are living on Social Security, for a young couple who want to move to this community. There's a lot of people who are going to suffer financially should you vote against this request. I just want to make one other reminder that our alternative theory here on the equitable estoppel argument, and that's in our written materials, but again, that's regardless of the factors for the variance. It is fundamentally unfair to hang the applicants here for doing what the town told them to do. And regardless of if you're not issuing a variance, we would ask alternatively that you also issue an order finding that the town is not going to take enforcement action against this garage. Because we believe if the town were to be filing a land use enforcement action, that under that de Grossier case that's in front of you, that a court would side with the property owners here because of that action. And it's really on all fours with that case. And again, I don't want to go into that unless you have
That's
questions.
beyond the capacity
it's-
of this board.
Well, you know,
For example, to issue an enforcement action or to issue a letter of no action.
well, we'd like to.
Unfortunately, I
We're
wish
not,
there
I'm
was
not
something.
asking for a letter
Yeah.
of no action, but we did want to put in there a request that, you know, the town is not contemplating taking any enforcement action here, and we don't
I see.
believe that it could on the basis of that case. So would want to preserve our rights.
Yeah.
Should we, you
Of
know,
course,
have to
yes.
appeal beyond this, we
Yeah.
want to be on record of that. But again, I also think that also goes to the equities about what action did they take or not take, you know. Just one final point about action by the applicant. It says action by the applicant or prior owner. It also doesn't charge them with inaction to fix the town's paperwork. It doesn't say they're responsible for making sure all permits are closed out and site visits are done and inspections are done. It says, did you do something, you know, that caused this, where it's your fault, not the town's, or not an innocent mistake. And we think that's what's happened here. Again, these are very difficult facts. I appreciate your wrestling with this. I would just remind you that this is a case-by-case determination. In this case, we think the equities favor granting the variance. Thank you.
Thank you. Okay, very good. Okay, guys.
Mr. Chairman,
Yes.
I will make a motion.
Yes, please make a motion.
Mr. Chairman, I move that we approve the request for a setback variance by Eileen and Terry LaFave.
Okay, please go slow. Okay.
I've got this written down. So,
Okay.
I move we approve the request for a setback variance by Eileen and Terry Lefrave, because we find they meet the requirements in section 17.3 B, 1A, and B, parts 1, 2, 3, and 4 of Durham's land use ordinance.
We have a second.
I'll make the second for sake of discussion.
Okay. Okay. And, just, okay, so we have a second. We have a motion from, Neil. And we have a second from Milt. Discussion, comment.
So I'd like to hear what you all think of the option that Ms. Malloy put on the table regarding the equitable estoppel.
The what?
He spoke about, am I pronouncing it correct? An equitable estoppel means we don't have to grant the variance, but there's an alternative way out of this in which the town says we won't go after, we won't.
I think it makes total sense.
We can't do that.
But we can't do it.
We can't do it.
Oh,
Yeah,
we as a board can't do that.
that's right.
Can the select board?
Well, it's already been to the select board. Or no, it hasn't.
The select board won't
I'm
offer
sorry.
this option.
I spoke too soon, so I guess it was suggested to take it to the select board, but the select board didn't rule on the issue.
Did they rule on this or did they rule on something else?
They didn't let that come to the select board. They didn't wanna see it. They saw it on the
They
schedule.
didn't, so it didn't come to a meeting.
Correct.
It wasn't proposed.
It was on the agenda, but it was removed. Is that correct?
Right.
So it's a decision that they make, we can't. We can make a recommendation.
Yeah,
Question.
yeah. But we could make a recommendation, I guess. I think that's
Before we
fair
vote
enough.
on his motion, don't we need to find out where we stand on B 1, 2, 3, and 4?
Where we stand with regard to, well, we have to have findings. You know, we have to present findings, so in one respect, you're right. You know, we could go through them, each one of them, and then have a bottom line vote.
I
That'd be
think
one way
that's
to
the
do
only
it.
way to do it.
Because part of the problem with getting a finding is that we don't have a lot of agreement. We don't have a lot of agreement. So, you know, what I'd like to do, I think it's reasonable actually to have a vote and then to discuss the findings. I don't know whether the vote's going to carry or not. So,
Well, the vote itself would say we have a finding, right?
well, what are those findings?
That we agreed.
You have to go a little further than that. You have to say why we
Are
agree.
you saying
We
the
agree
motion
that it
says that
meets
we
them.
agree on all 4 of them?
Well, that's good.
Yes.
Yeah, I mean, that's fair enough. Yeah. So we're not
Well-
denying.
I'm saying
Yeah.
they meet the
That
requirements.
ain't
Yeah.
right, I don't believe it.
Well, but the only thing about that is, I think that if you are going to provide, if we're gonna vote on that motion, we should probably have some statement of why, to make that motion stronger, why you feel it meets number 4.
I would agree with that. In previous
Yeah.
votes of this board, we would have taken this one by one and then done a vote for the whole thing. We wouldn't have skipped that step.
Yeah, I think in this case, you at least have to address number 4, because number 4, or, 3 and 4, right, sounds like 3 and 4. So I guess we would, ask for, that amendment to the motion. And again, that's because, we're charged not only with voting, yes or no, but we're charged with delivering findings and writing a decision.
Where does it say that?
It says it right in the ordinance.
And
And I'm the one who has to write it.
wouldn't it?
And I'm not going to be guessing, okay? We're going to agree on what those findings are, but we're gonna have them in the motion.
Should I withdraw the motion?
Yes,
I
I think
withdraw
that'd be a
my
great
second.
idea. Yeah,
Yeah, I'll withdraw the motion.
okay, very good.
So as I said, the way something like this has been handled previously is we would discuss each of the 4 points.
And if any of them failed, that took care of the motion
Well,
of
that's,
the variance.
it's not that simple. I would suggest that we still, even if one fails, that you still have a bottom line vote at the end. because, oh, I see,
You'd have to have a motion and a vote on each of the article, of each of the items,
individually.
yeah.
Correct. All right,
And
well,
it's my understanding they all have to have an affirmative
Okay.
vote in majority or a non-affirmative vote in majority, and all four have to either pass or fail, each or individually, and that would determine if the variance is allowed or not allowed.
I think that's a reasonable approach, Terry.
That's the way I've always understood that for years.
Yeah. Very good.
So just a point of order, so I'm not, just to clarify, we have 4 voting members. So if the vote was 2-2, if it didn't have.
failed.
It would fail, okay.
Yeah. Okay, very good. I think that's a reasonable approach.
So,
Okay.
do we want to have a motion for each of item B, 1, 2, 3, and 4? Or we're gonna start with 1A?
I think we need to start with 1A. Hold on just one second here, you're gonna have to bear with me here. Okay, so, Neil, if it's okay, can we have Neil make the motions? And just to
Sure,
kind
go
of
ahead.
expedite things here.
Yeah.
Neil, could you give us a motion, and then we'll take a second? So Neil, could you give us a motion on,
It's 1B,
yeah, on 1A?
1A.
Yeah, 1A, that's on page 158, dimensional variance.
Well,
So
what-
the
what
pro-
what are we doing? We're voting to approve that we agree?
Sure, yeah, I mean, it sounds like that's the direction you're going, you're certainly welcome to do that, to make a motion to approve, to approve A, you would say, I move that we approve that the proposed structure or use would meet the performance standards of this ordinance, except for the specific provision that has created the nonconformity for which relief is sought. That would be the motion.
Make that motion.
Okay, and you could also add to that, because we have asked the code enforcement officer whether there are any other nonconformities, and he said no.
And specifically, what is the provision?
That it meets otherwise meets the performance standards, that this property otherwise meets the performance standards.
Right, except for the specific provision.
Yep,
What's the provision?
Except for that.
yeah, the setback
In this
issue.
case, it's the setback.
Right, okay, so basically what this is saying, that otherwise the property meets the ordinance, okay?
But it doesn't.
Otherwise, except for the setback issue.
Okay.
It meets the ordinance. And the code enforcement officer has said yes, that other than the setback issue, it meets the ordinance.
Okay.
Okay, so do we have a motion? And you don't actually, if you keep the motion pretty close to the text and just add your reasoning at the end, that's perfect for me.
So Neil, you made that motion?
Yeah, I move we approve that the property meets the requirements of 1A based on what the code enforcement officer has told us.
Okay,
We
meets
did- we did.
requirements 1A based on what code office, based on the fact that the code officer said it otherwise meets the requirements.
Should setback be in there somewhere?
No.
No, not yet.
That's the exception. That's what they're talking about in there, the exception. That's the reason why that's the nonconformity.
Okay, so we have a motion, and again, that motion is that the property meets the requirements of 1A based on what the code enforcement officer told us. Is that correct?
Yes.
Okay.
And I'll second that motion.
Told us, okay, and that's Neil and Milt. All right, discussion? All those in favor? All right, and that's 4-0. Opposed? Of course, we're unanimous, that's good. All right, number 2. Or B, I guess it is. Okay, 1A and 2B. Neil? Okay, so B, we start in with, B1 would be the first one, correct?
Yeah.
Yeah,
Under the I move that under the hardship, undue hardship requirements of B1, we approve B1.
undue hardship. Could you add a little more to that, for example, just a suggestion, as, for example, it's been demonstrated to us that they cannot sell the property? That seems reasonable. Why do you believe this is a hardship?
Because we're on social security, and anyone on social security these days can't sell the property for full value is not getting a fair return. Keep it simple.
How about we just say they can't get a fair return?
That's what the.
Leave their economic status out of it.
That's what the whole thing says.
Okay.
Can't-
All right. Can't
Not gonna get a
Sell.
return.
for reasonable return. Return, is there a second?
I'll make that second.
All right, so we have Neil, and we have Milt. And again, the motion is, under undue hardship requirement B1, that we approve B1 because the applicant can't sell the property for a reasonable return. Is that correct?
Yes.
Thank you. Okay. All the discussion. All those in favor? All right, we got 4-0. And number 3.
2,
Oh, 2.
Well,
B2.
Oh, yes, thank you, 2, B2. B2. All right, Neil, or whoever would like to make a motion.
I'll make the motion.
Okay. Mill.
I make a motion that let's see. The application of the terms of the ordinance
Number 2.
would cause I don't know how to add that first paragraph, but the need for variance is due to the unique circumstances of the property and not to the general condition of the neighborhood.
Okay.
That's my motion.
Okay, so the need for
Just what,
variance is due to unique
could we say the shape of the property?
shape or circumstances, okay, well, not circumstances of property,
it's circumstances, because it's taking into account more than just the shape of the property.
not the neighborhood, okay, including, okay, shape, and location of the front door of the house?
Yeah, that's good.
Yeah, or side door. And how, home entrances, does that make sense?
Yeah, home entrance is good, I like that.
Including shape of property,
And not the general
And-
conditions of the neighborhood.
the home entrances. Okay, so what I've got here is the motion is the need for variance is due to the unique circumstance of the property. not the neighborhood,
And not.
comma, this includes the shape of the property and the location of the home's entrances. Okay, is that pretty much it, Milt? Did I capture it?
Yes.
Well, I thought, I was thinking circumstances included, also include the administrative
Oh, the administrative, okay.
error.
Okay, okay, can I just add that? Yeah. And the administrative errors. Administrative errors, okay? Very good.
Should we be changing the wording of what's in the book?
Well, no, you're not, you're using basically the same wording, but you're just adding the why.
Okay.
You're adding your rationale for why you're proving this. You're giving your reasoning. And it's important to be able to give your reasoning for, why you're approving or why you're denying. At least that's what I've always been taught as a town planner and planning board meetings. So, if you want to have a decision that's going to hold weight and it's going to stand up, it's important to do that.
I second the motion.
Okay, so I've got a motion from Milt and a second from Neil. And the motion is that the need for variance is due to the unique circumstances of the property, not the neighborhood, comma, including shape of the property and the location of the home's entrances and administrative errors. Discussion. All those in favor? Okay, 4-0. Move on to B3.
How is it, the land classified, the land use classified, rural?
Rural residential.
Rural residential?
Yeah. And again, B3 gets to essential character of the locality. And it's that the granting of a variance will not alter the essential character of the locality. And I think to Terry's point, I think it is good if we can keep the motion close to the wording, that's a good thing. But just add why.
Who needs water? There is a water cooler in the office to the left of the kitchen. In there.
For example, one could make a motion that, let's see, that I move to grant the variance, that granting the variance will not alter the essential character of the locality as the structures, will be the same structures. And this is a rural residential classification with some properties that are grandfathered and have reduced setbacks. Something like that. That was just an example.
Second.
Okay. Would someone else like to make that motion? As chair, I like to provide examples, I don't like to make motions. Okay, well, very good, I'll make the motion then. Okay, so Paul and then Terry. Okay, give me a minute here.
Neil and Terry. Motion and second.
Okay, so again, the motion on the table is granting of the variance will not alter the character, hold on. The variance will, the essential character of the locality
Which is rural residential.
as the property is zoned rural residential and includes other properties that are grandfathered with reduced setbacks. Discussion.
Just a question for Alan, if I could. I'm not sure if it's pertinent or not, but it's just to have my question answered. So, and on properties that are grandfathered, when they get sold down the road, that's the grandfather carries for infinitum.
The existing structures are grandfathered. Additional structures that they would put on have to meet the current ordinance.
Yep. And the variances work the same way, once the variance is granted, if, let's say, the new homeowners at some point are gonna maybe move on and sell the house, will that variance be in effect then for the,
Actually, if a
Next.
variance is granted, it's the responsibility of the person receiving the variance to register that with the registry of deeds. And it has to be done within 90 days. And that cements that variance for that property. Just a note. If you
An
don't
important
do it
note.
Within 90 days, it's null and void, there is no variance.
Okay. All right, very good. So, any further discussion regarding B3?
That's Androscoggin County Registry of Deeds.
In that case, all those in favor of 3? Okay, and opposed?
You opposed, Terry?
Okay, and we have 1 abstention, sounds like.
Yeah.
Okay,
you abstaining or voting no?
Abstaining.
You abstaining.
okay, I'll make note of that. Okay, so moving on now to B4. All right,
I move we approve that the hardship is not the result of the action taken by the applicant or a prior owner because they trusted the contractor that they hired to submit the application properly, and they trusted that the town would review the application properly, and the town approved the application.
Totally disagree.
action, and you're saying because they trusted the contractor,
Maybe there's better language than that, trust.
okay,
I don't know what it would be either.
Can't do that.
is there a second on this motion? Someone? So,
If I may,
yep,
I have a problem with that. I think we need to put the motion as it's written in the book.
yep, I agree. Okay,
Just skip the explanation.
look, can you make it? Make it.
The hardship is, I'll make the motion.
Yeah.
The hardship is not the result of action taken by the applicant or a prior owner.
The result of action taken
By the applicant
by the applicant
or a prior owner.
or a prior owner. Thank you, Terry.
I second.
And hold on, why? And I think, you've really gotta say it on this one, because, and the reason you have to say it is because, these are the owners, the owner is the applicant.
Say that again?
The owner is the applicant,
Yeah.
right? So why isn't it, the result of action taken by the applicant? Got it?
Because that's what it says right here in the
Okay.
book.
Okay. But why is it not the result of action taken by the applicant? So is it because you're just saying period? That's it? Or are you able to say,
The hardship
expand
is
on that.
not the result of action taken by the applicant or a prior owner, period. That's the way it's written in the ordinance book.
okay?
Now,
Okay.
we know who the applicant is. We already know that,
Yep,
but I don't believe that that's part of the motion.
okay. All right, very good. Is there a second?
I second it.
Okay. And, discussion.
So, Terry, I just want to hear more of your point of view. So you feel that it was a result? That, I think, I'm anticipating how you might vote based on what you've been saying. So I'm just asking, I'd like to, just I'd like to know what you're thinking.
My thinking is that the applicant, no, let me put it to you like this. The applicant was Smart Homes Improvement. To me, he's a subcontractor of Terry and Ellen Freed. So he is working for these people. These people are the owner and the original applicant for the permit. These people just went and got it. And I still feel that the applicant is the owner. Am I correct or wrong?
The applicant for what? The applicant for the variance?
Permit,
Or for the permit? Okay, for the permit.
okay?
Yeah, so you believe the applicant, okay, got it. So the applicant for the permit is the owner because, Smart Builders, or whatever their name is, was
Work
working
for
for them.
them.
Okay, gotcha.
Okay? And the applicant here is the owners.
Uh-huh,
So
Okay.
that's what I see. Now, granted, Smart Home Improvement got the permit,
right,
but they got the permit for the owners of the property.
right.
I mean, they probably included that in the price or whatever they did to build a garage, but
Uh-huh, fair enough. Okay, so,
and I'm sure that the owners was aware that the permit was gonna be issued to them people, but they knew that they were gonna go get it.
mhm,
I mean, I've had construction in my house, and the first thing I ask people doing, you got a permit? Oh, yeah, we went and got the permit, done deal,
mhm,
you know,
Yep.
so, I mean, you have to keep up with things, so that's my feeling on it.
okay, yes.
So Terry, what role do you feel the town plays, if any, in this?
The town took the word of the contractor that all of these things were within reason and met the ordinances.
Kinda like they took the word of the builders.
Mhm. Okay,
I mean, and the builder wanted the job, he got the permit, so he got the job.
of course, we don't know anything about the order, or like how that happened.
Right.
We can't speculate,
You're right,
but we know that he got the job, and we know he got the permit.
right.
Okay,
So that's how I feel about that.
okay, so, again, your motion was motion that it's not the result. of action taken by the applicant or a prior owner.
Or do you want your motion to be that it is?
The
The
hardship
result.
is not, it is,
Is the result.
is a result.
Yeah, so, you know, that's what we're trying to figure out here is, because what your motion was the opposite. Your motion said,
Wait a minute.
yeah,
If the hardship is not the result of action taken by the applicant or a prior owner, then the vote would be no,
mm-hmm,
not a
Right.
positive vote,
okay, I see, yeah,
okay?
okay, yeah, okay, yeah.
I don't see, say it again.
Because if it's a positive vote, you would be saying it was not the result of the,
Okay, it's semantics, making it a motion, making it into a formal motion versus just reading that section of ordinance.
right.
Yeah, so, you know,
He's entering, section 2B4 for a vote, so he's entering it as written and making the point that
yeah,
if you vote in favor of it, then you're in favor of it as written. If you vote against it,
yeah,
then you're voting contrary to the way.
yeah, maybe you could just amend your motion to, just to, you know, I just wanna make sure this is clear. So,
Well,
If you vote in the positive, you're saying it's not the owner's responsibility.
right.
yeah, I really think that you should change, I would really recommend that you, and I'm sorry, I know it's kind of semantics, but it would help us keep things clear. If you could just say, make a motion that the hardship is not, oh, I'm sorry, the
Is.
hardship is the result of action taken by the applicant.
You can't do that.
Okay? You just wanna vote on up or down, on,
It has to be up or down, because if I change it and everybody votes yes,
okay,
okay,
yep,
then you have a positive vote on all four. If you vote no on this because you're saying it is a responsibility of the applicant, then one of the four fail.
okay,
Yeah, I think it has to be entered in the record the way it's written,
okay, very good.
and then voted up or down.
I mean, we can't be changing the wording of these ordinances, I don't believe.
Okay, so, your motion is, the hardship is not the result of action taken by the applicant or prior owner.
Yes.
Okay, got it. And we have a second on that already from Neil, right? All right, very good. Further discussion?
I would really like to hear both of you, your point of views.
I think the town is responsible here. I don't think the applicant is guilty.
And the town is responsible based on the actions of whom?
The man who signed the permit. The code enforcement officer.
Okay.
He approved the permit.
By what he was told.
Go look,
What's that?
go look. That's what they do now.
Right, there's nothing preventing him from going to, the mistake he may have made was, so he just took, that he didn't go check.
It's
If
an
it's a
interesting question.
mistake.
Now,
I don't know if it's a mistake, but
I think it's beneficial to go back to what Alan said with regard to, for example, you know, when the application materials were provided initially, you kind of take it on faith, right? Because when you first register the application, you know, you haven't checked yet. Nobody's checked yet.
I mean, when the contract steps through the door, I don't believe the first thing you say to them is, I think you're dishonest, and we're gonna have to check you from top to bottom. I
Yeah.
don't think that's what you do, is it, Alan?
That's what-
Everyone coming through my door, I think, is dishonest.
Absolutely, that's what I was,
Well,
just what I was gonna say. Just what I was gonna say.
That
They're
is,
lying,
that
they're lying to
is,
anyone, they're lying to me.
that is in this case.
So Alan, if I can ask you, I mean, so is a scenario that if the CEO doesn't check the the information on the application, he has to check it at some point, right? Because he has to, doesn't he, at some point in the project, the CEO has to approve or write it off or give an okay? Doesn't he have to do an inspection?
Yes.
So is it typical that the CEO would wait until after a structure is built to then inspect it and say, no, this isn't right? Or would they do it beforehand so that a structure wouldn't already be put up?
I can tell you what I would do. I can't tell you what they would do then, because I'm not that. I'm gonna take an application and look at it and look at their, I'm gonna bring the lot up on the GPS and look at their lot and say, oh, that looks really close to your property line, or that looks fine. I'll check it when you put your stakes out.
Or maybe on the tax map, if not on the GPS.
The GPX does that. The
Yeah, I
GPS
know, but
does have
I'm just
tax
saying,
maps,
you know, you
yes.
have some code
Yeah.
enforcement officers who are GIS capable
Yes.
and some that aren't.
Yeah, I'm gonna get an idea
Yeah.
about that location. If I look at it and go, oh, yeah, I'm gonna have to look at that. I'm gonna have to come out and look at that. I would say that. I need you to stake that out, I'm gonna come and look at the stakes. And we're gonna measure where we think the property line is and go about it like that. If it's in the middle of a field, I'm gonna go, oh, yeah, that looks good. And I'm gonna check it still now. Would I check it back then if it's in the middle of a field? Nope. No. Now is a different story.
Based on your experience, the CEO, at some point early in the building process, probably before the structure goes up, would probably come and do some type of an inspection?
For concrete, for framing, yes.
Okay. And in this case, we don't have any record that that was done.
I still have the question of, you know I work in the trades, and the inspector just doesn't stop by, unless they're concerned about something specifically. They wait for you to call. And I know if it's a busy time, they can lose track. They can think, oh, well, they probably just haven't started construction yet, or maybe they haven't driven down your road. They have to, the builder has to call and say, Alan, I'm ready for an inspection. Otherwise, you've got no idea what's going on, unless, you happen to check up on it. But it's really up to the builder to tell you.
Which doesn't happen often. I don't have free time, even if I'm driving by
Yeah.
a place and I think, oh, they got a garage permit months ago.
Yeah.
I don't have time to go look at that. I
Yeah,
got things to do.
So-
exactly.
You're saying, so if you were the builder,
Yeah,
and there was any concern on your part, you'd probably ask the CEO to come and do an inspection or come look at it, but if you either didn't care
yeah.
or had no, thought we're perfectly good, you wouldn't bother to have them come inspect it.
Yeah, I think, this is a spectrum, okay? You got guys who play by the rules and they know, and they've been doing this for a long time. And builders, this isn't just Durham's convention. Usually there's an inspection when the slab goes in, right? Usually there's an inspection for framing. And then usually there's a final inspection. If there's any electrical, there's an electrical or mechanical inspection. So, there are different pieces, and those aren't just Durham's rules, they're generally accepted practices,
You have no
for
records
permits.
of any of those inspections?
No.
Based on your knowledge, there were no inspections because there was no paperwork or any documents submitted?
There's more than a few instances when I don't have documentation. And that's true on this.
Yes, Byron.
My question, Alan, when you're hired by this town, are you given job guidelines or the job description?
State statute.
State statute obviously comes into play, but I mean, there's obviously gotta be some expectations from the town manager of what the duties are, correct?
Yes, and you're certified in certain things.
in your predecessor, or the gentleman who was doing, or whoever was doing this job before, would have had to have had that training, right? Okay, so there is an expectation that they're going to do what they're supposed to do.
Yes.
And I'm also assuming that if you get an application, or you get 100 applications this year, that some of them get followed up on a hunch, or maybe you hear something, or maybe you just wonder why do I have all these applications and I haven't had any call to go inspect these things? They don't all just sit there in a pile, do they?
Well, not everyone knows the importance of a final inspection. And sometimes they don't call for that.
Yeah.
That's very unfortunate.
Does our application process discuss that?
Yes.
Okay.
You
So, I
must-
mean,
you must
they're
be
presented with
inspected.
that information.
Yes.
Okay.
And they sign the application.
Right.
So they know that they're supposed to be inspected. However, lots of times they don't.
Sure.
And I honestly don't follow up on every single one.
No.
Those applications have to be processed. Do you know what happens after the permit's expired? It goes into the property file unsigned.
Right. But that's proof in the pudding that
It is.
that it didn't get completed.
Yes, and it may not, as Alan said, it may not have completed because they didn't call.
Correct. That's
They
possible.
didn't call, or who knows, or maybe they didn't finish.
Maybe they didn't, maybe they
Yeah.
didn't finish.
Right.
Thank you.
Okay, others, in terms of number 4. Okay, so I'll take this opportunity just to weigh in with my thoughts. I think that, all of these things are important to this circumstance. I think there's a lot we can learn from this case. I think the process starts with a fundamental thing, which is the site plan. And the site plan is kind of key to everything in the building and planning process. And in this case, the site plan was, not only was it inaccurate, it didn't reflect the site conditions. And I think the town could have done a better job, but I think ultimately the applicant, if the applicant is, for example, getting messages from another town official that they should really do something different than on the site plan, that they need to come back to the code enforcement officer and say, I need to amend my site plan, or this person has told me this. Because ultimately, the code enforcement officer and the permit is what guides the approval process here. And they're the municipal official with jurisdiction. And yes, the public works director can say, we want the entrance right here, and, we want the building back from the road. But those are, as the applicant stated, for example, that the driveway should be as close to the mailbox as possible. Those are more in the realm of as possibles, and they need to be brought back, and it's a reasonable expectation that it then goes back to the code enforcement officer. I feel that in this case, not only was the site plan inaccurate and not possible to follow, but that the applicant didn't come back to revise it when they realized. And when I say applicant, I'm referring to the owner and the building permit applicant. But they didn't come back to revise the site plan. So that's why while I would like to see this be taken care of and wave my magic wand and have this be done with, I don't think I can vote for number 4. Yes?
I don't understand your logic. The site plan was submitted with the requests suggested by Calvin, if he didn't suggest them before the conversation.
I don't think
There
we
was,
know.
there was no need for them to go back.
Well, yes, of course there was, because the building was moved to within 20 feet of, if you look at the side setback in the site plan, it says,
They had no knowledge they needed to go
it says
back.
20 feet.
You're suggesting they had knowledge they needed to go back, or should have had knowledge?
If the public works director was suggesting something that wasn't on their site plan.
How would they know?
They have the site plan, they submitted it.
They didn't submit it, the builder submitted it.
Right, the builder is the owner's agent.
I don't get your logic, Paul, but.
Paul, why couldn't they have why could, I mean, whether it was the public works director or anybody, they could have listened to him, or they could have said, not listened to him. So, if they had chosen, in a way, they were threatened, because if they had, in their mind, if they, chosen, well, we're all set to go, we've got our permits and everything, and the public works director is saying, I'm gonna tear it down if you put it where you want to. See,
Would
you
the
both,
public
you
works-
both have good points, and so I'm trying
Yeah.
to figure out, I'm still in the middle of that seesaw.
Yeah,
So,
it's
you know-
kind of a cup half full or half empty type of thing.
yeah, I mean, so it's a mistake by the town if in effect he threatened,
Yeah,
we'll tear it down, then
Okay.
they're gonna believe, then they might believe him.
okay, well, I think there's another point here, and that is that, it's up to the applicant to provide a burden of proof. And we do have a statement here from these folks, from the applicant. But does that provide a burden of proof? I don't believe that it does.
Was there a request for the public works director to attend?
I don't think it matters. The town approved the sketch, the drawing. The drawing was wrong, they approved it.
Yeah, but I
Nobody
think,
double checked
But
that.
it wasn't put where it says it was gonna be put on the permit.
Wait a minute. They didn't approve it. They accepted.
they accepted it, thank you.
They accepted it. They didn't approve that sketch.
And the applicant signed something basically saying that to their knowledge, this is all factual and true.
Right.
Yeah.
Can we call a question?
Well, that's another motion. If it's a motion, I'm voting it down, because I'm not done.
Okay, okay.
So it does say that on the application.
Yeah, that it's, can you read that, or just read it
It's
section?
signed by the owner or applicant. I certify that the information contained in this application and any related submissions to be true and accurate to the best of my knowledge. I understand that I'm responsible for the compliance with all the applicable town, state, and federal regulations, and that failure to comply may result in the imposition of fines, legal fees, and the abatement of any violations to include abandonment of use and occupancy and blah, blah, blah.
Thank you.
So, a question, was based on this building permit, was the garage located where it was permitted?
No. And that's because the side setback on the building permit is 20 feet. So, and it's not, it is 6 feet from the sideline.
Well, I would say it was located where it was shown to be, except that the back line was wrong. It's 90 feet from the road, next to the house.
I think it's kind of a black and white, in my opinion. Either it's located in the right position or it's not. There's no halfway, is the way I would look at it. Either it's violating one setback and it's not in the right location, or it is.
So that's what I need to know that, whether it's you or Alan. Is the garage located where it's stated in the permit it's supposed to be located.
It can be if it's 6 feet from the property.
But that's not part of the permit. That came afterward. The permit shows a schematic, and a permit shows verbiage. My question is this garage located where it was permitted to be?
No. There's inaccuracies in this drawing. So you can't, I can look at this number and say, yes, 90 feet from the center line?
Yes.
It probably is.
Met that one.
50 feet from the sideline, it might be, I'd have to look at that. 50 feet from the back line,
I thought the sideline was a violation.
that, it's, well.
Whether it's a side or a back,
doesn't matter.
The line goes.
semantics.
It's the back, yeah, the back.
Yeah.
So, initially, it sounds like it's a town's mistake. But that's why this question I'm asking, I think is so important, is the garage place located where it was permitted?
Well, the one thing that we knew for sure is where the road is. Nobody knew where the back line was.
Yep.
So it's located exactly where the road says it, from the road setback.
But it is up to, I think, any judge in the case, for example, a forestry cut. You know, you're cutting your property of trees, okay? And if you cut over the line and you cut a half dozen of your neighbor's trees, the neighbor gets upset and says, I'm gonna take you to court, and they take you to court, and the judge says, assesses double stump damages. I think the judge would say, it's up to you to know where your property line is. You have to know where your property line is. Ultimately, I think the property owner is responsible for knowing where the property line is.
The application says to the best of their knowledge. They said to the best of my knowledge, that's what I understand it to be.
How do you respond to Paul's scenario that he just gave?
Well, the judge?
Because that's a real life situation. If a guy cuts
I don't know.
trees on,
I mean, it's just, we don't have to go down that rabbit hole.
So we'll have to do that.
Yeah,
well,
but
it kind of does, puts relevance to this. I'm trying to,
I
I want to make sure I understand both of your way you're both thinking. Because that is the brunt of this. Is it the responsibility of the owner to know his property line?
Yeah, I think it is.
I got to be honest with you, Milton, I gotta think that 99% of the people that live in this town can probably tell you exactly where their property line is,
But you can't.
within a few feet.
Well, I don't know about that.
But how many of them would be right?
Huh?
Good point.
My neighbor can tell you where the property line is, she's never right.
Yeah, but I do think from a legal perspective, that is their responsibility to know where their property line is.
Or within
Yeah,
a few
because-
feet.
Well, look, I mean, what about, cutting your grass? What about all these other functions you take up, where you park your boat, all those things? You have to know where your property line is, because you don't want to, you don't want to be infringing on other people's rights. I just think that's the way the law works. I find it difficult because, I would love to, nothing more than to approve this and, help these people on their way, but I have a hard time getting over
So
those
the people
points.
who could be infringed have said they don't care. They don't feel like their rights have been infringed.
Yeah, that's right.
I think if mercy has come to play here, it's easy to interpret number 4 as not their fault, because the town was involved in this decision. The town could have helped remediate this problem if they had
Right.
done their job more thoroughly. Maybe it was nobody's fault, maybe it was just an accident,
Yeah,
but nobody was injured in this whole thing. Nobody was injured. the abutter doesn't care.
Uh-huh. Butter doesn't care today.
We don't know about the new
This
owner.
abutter doesn't care.
Right, there's gonna be a change of ownership at some point.
The,
But when they do, they'll see the variance before they close on it, so they'll have agreed to it.
God, the absolute easiest thing would be if they just sold them a little piece of land and,
It's not easy to do.
It's not, it'll take 6 months.
you have to get a survey, there
I
are steps,
understand.
there are steps.
yeah.
You know, but I do think that, you know, this abutter letter does add more relevance to, and I don't know if that was provided to the selectmen initially, when these folks came, or when these selectmen were approached.
You never went
Yeah.
to this one.
Can I just clarify that point about the selectmen, because I believe it wasn't as if there was a consideration in
Yeah.
a ruling on anything.
I know.
And they declined it.
Yes.
You know, I think I saw an email, the town attorney suggested that because there's no enforcement action, there's no consent agreement to be made, right? I think that's why it didn't get before them.
Oh,
You know,
okay,
Okay, a
Yeah.
consent agreement, under one theory, is that it's a settlement of a lawsuit.
yeah,
And
yeah,
that's why
yeah.
that's different from changing zoning regulations, you know, so
Yeah,
the
well,
town has home rule authority to settle a lawsuit, but
that's interesting, because I've seen it in cases like this be used in, you know, in another contexts.
the town hasn't taken any issue with this
Yeah.
and is not taking any enforcement action, so here we are, unfortunately.
Right. Yeah.
So, talk about that a little bit further, so, it's right now, you said, so right now, it's not a problem with the abutter.
Right.
So what are possible scenarios? If a variance is given, then that's the end of the story.
Yeah.
Even if the abutter changes their mind later on.
Well, it's interesting, because I guess, you know, you could look at it from the perspective of, you know, if someone were to appeal the decision of the appeals board, it would have to happen in a certain period of time, right? They have so long to go to Superior Court to appeal it. And, you know, the odds of the property changing ownership in that time are pretty, you know, pretty small. So after you get outside of that window, then the chance of legal action is probably pretty low. Does that, I see you kind of nodding your head a little bit, yeah. So,
And if there's a new owner, once the variance is in place, then it's a moot point.
Well, they know it, so.
yeah, right, good point. They're noticed, yeah. Yeah. It's true.
Oh, my God.
All right, so we're back to number 4. We have a motion here. We've had discussion. Are we ready for a vote on this?
Paul, I'd like some clarification as to what your vote is gonna mean.
Absolutely.
Because I don't know exactly.
Okay, so we're voting on the criteria individually. This will be the 5th vote. This is on B4. And the motion is, wake up here. The motion made by Terry is that the hardship is not the result, or is that the motion is that the hardship is not the result of action taken by the applicant or a prior owner.
So am I correct in understanding a yes vote means you're saying the hardship is not the result of action taken by the applicant or prior owner?
Exactly.
A yes vote means that it is not the result of these people.
Right, exactly.
And a no vote is, it is their fault, what's happening.
Right, exactly.
And before we take the vote, so let's say it's split.
Yeah.
Do we then, is it done, or do we still do we still have a final vote on whether to issue the variance?
Yeah, you know
With
what?
an explanation.
I'm the chair, and I'm gonna make you guys take a bottom line vote, just for absolute clarity. And just so there's absolutely no question, I'm gonna call for a bottom line vote after this is done. And if the bottom line vote doesn't match, you know, how people have voted on the other 4, that could be problematic, but we're gonna do it anyway. Okay, so, again, we have a motion on the table, and a yes vote means that the hardship is not the result of action taken by the applicant or a prior owner. A no vote is that the hardship is the result of action taken by the applicant or prior owner. All those in favor, please raise your hand.
Voting yes.
Voting yes. All those in favor of voting yes, please raise your hand. Okay, so we have one yes, and that is Neil. All those opposed, please raise your hand. Okay, so, all right,
I'll make a motion.
okay, thank you.
I make a motion that we approve the variance.
Can't.
We can, he asked for a bottom line vote.
Okay, yeah.
Because I'm gonna say that there's.
Can you make a motion to deny? Let's just keep it simple. I mean, if you plan on voting, I don't know how, but, you know,
Well, because I want the motion to state that there's, I don't know if it's equal fault, but there's fault on both sides to merit the variance.
If I may,
yeah,
if I understand the rules right, is if any one of the four fail, if
Yeah.
any one of the four here fail,
you can't approve it.
it cannot be approved.
That's right, and
So
you
what was
failed
your-
four.
So
Hey,
your
vote.
bottom line vote that you were gonna say,
Yeah,
was that was just to,
it's just a formality and clarity, but it really, as I said also, it needs to reflect how you voted on the other items, and the fact that, I mean, look, this, unfortunately, number four has failed, and so, you know, it doesn't look to me like this variance is gonna pass, but we're gonna do
What do you mean?
this bottom line vote is a
Can you
formality.
explain that, Paul? What do you mean, doesn't look like it's gonna pass?
Okay, because if you look at the ordinance, it has to meet all four criteria.
It has not,
And it has not, exactly.
so it can't pass.
That's right, it can't pass.
Now,
Because
does the
your bottom line would be inconsistent with the individual lines that you voted on.
so now these folks can now go back to the select board with their attorney to request the
Letter of no action.
Yes.
equitable estoppel?
And I think that's an interesting point, because, you know, I did hear some language or reference from the attorney with regard to, that, you know, these are avenues that they wanna keep open. And, you know, I don't know, and of course, that's not something we can vote on one way or the other, but I think that, you know, it is something that we could, make suggestion or recommendation.
Yeah, so if this board if our recommendations are considered by the select board, then I think as a board, we should make the recommendation that the select board hear these folks out.
That they hear it, yeah,
Because they have not done that yet.
yeah,
And
I
I think
agree.
their attorney should be present,
Yeah.
and I think his option is
as soon as possible.
merit, yeah.
Yeah.
Yeah,
Yeah.
like at the next
With
meeting.
regard to a letter of no action.
Yeah, they got a meeting
Yeah.
coming up, and so we're only delayed by less than a week. I think the next meeting is next Tuesday. There's no reason why you can't be on, the agenda for next
Well, it
Tuesday.
depends on what's on the agenda now.
Yeah, I mean,
Well,
we can't speak for the town
well, true,
manager
but-
and the select board. But we can make that recommendation
Make-
as soon as possible.
Yeah.
So, you know, you could make that, for example, as part of your motion or separately. However you like.
What do you mean by separately?
However you like, Milt. Just, I'll leave it to you to make the motion.
So I make a motion that the appeals board recommend that the select board, consider,
Hold it, stop. Before you do that, take your bottom line vote. Make your motion on whether to deny or approve the project, or the variance.
we've already done that. We said we can't go back and do that.
He wants a bottom line vote.
I want a bottom line vote. So, and I'll make the motion.
So it's just to be redundant?
Yes, it's
Okay.
just to be redundant. I'll make
So I
a,
would argue if we have a bottom line vote that passes, then question 4 gets passed automatically.
okay, yeah, you can argue if you like. I won't,
Now, according to
I won't
the
go there.
ordinance, if all 4 of those fail,
Then this is, there's no reason to do this vote.
I agree. I don't think there's a reason to do the vote. It's-
okay, then I will just make the statement that the consensus, or that the vote of the board is that the variance has been denied,
Because because not all 4 of the,
because not all 4 criteria, or not all the
Criteria.
criteria have been met.
correct.
Yeah, very good.
Now I make a motion that that this board recommend to the select board that these folks get immediate, or have their, I don't know how to put the wording, but have their equitable estoppel considered, if we're gonna go with that verbiage, as soon as possible.
So,
I'm not sure equitable estoppel is the right
Oh.
verbiage, because.
oh, yeah,
um,
we're almost done. Okay,
We'll take a brief pause.
my wife gets awful upset.
I don't know what the verbiage is,
all
but
right,
my
Terry.
recommendation is that the select board meet with these
Okay.
folks, put it on their agenda at their next meeting.
All right, well, maybe we could get the correct verbiage here from the attorney.
Again, we're just looking for a,
No action letter?
finding that this board would support a no enforcement action taken by the town on the basis of those.
Okay.
factors.
Yeah, exactly.
And that, Mr. Malloy, how does that, will that affect the new homeowners at the next time this comes up?
I can't speak to that right now.
So, but this, just as I mentioned, got the new homeowners to know that they need to go to the registry of deeds. They need to understand whether or not, if they do get this no action, that they might have to deal with this at some later point.
They're gonna have to talk to their counsel and their title insurance company and what that means, and I think that's requiring a fair amount of speculation about what could happen after tonight.
Yep.
So I can't really.
Yeah, and I think that's probably a discussion with the select.
Yep.
Right,
But
this
but
is-
if
that's
they
not really in
get
our-
what they're seeking, what you're suggesting, their sales can move forward.
Correct.
Okay.
Okay, that we, Milt, would you like to go ahead and finish your motion?
That the Board of Appeals recommends that the select board,
Consider no action, letter of no action.
at their next meeting,
Consider or approve?
approve,
Consi-
or consider, I don't know which is.
I don't think we want to
No,
tell
I
them
don't
what to do.
think approve
Consider.
is the answer.
Yeah,
Consider.
consider.
At their next meeting. And so-
If you write approve, that's the sure way to get it turned down.
So what you would need to do is you would need to call the town office tomorrow to get on to
Agenda.
request to get on the agenda.
Okay, hold on, folks, we have a motion on the floor,
Yep,
so I'd just like to have some order for a minute.
yeah, I'm sorry.
Do we have a second?
Second.
Okay, so we have Milt, and we have Terry. Okay, and the motion is for the Board of Selectmen to consider a letter of no action from the applicant at earliest convenience. Yeah, is that right?
Yeah.
At earliest convenience.
I'd say as soon as possible.
Okay, as soon as
As soon as
possible.
possible, I would agree.
That's better.
As soon as possible, would be then. They have a meeting next
As
Tuesday, I believe.
possible. Okay, we've got a motion, we've got a second, we have discussion. All those in favor? Okay, very good.
Mr. Chair, can I add a statement?
Yes,
because you've been denied a variance, you do have the right to, take
Thank
this to Superior Court.
I'm sure.
So you have that opportunity. Also, you could ask the select board, it's in the ordinance, but it's, you're not being enforced, there's nothing being enforced at this point. But they can issue a consent agreement if you're in an enforcement situation, which you aren't, so that's. And another remedy is you can remove the violation in some way. So I just wanna make sure you understand that you have those options.
By a piece of
Could I just ask, will written findings and conclusions be forthcoming from the board?
Yes.
As described in the ordinance.
Yep, so.
Yep.
For those, thank you.
Yep. Okay, very good. Thank you all, thank you applicants.
So how do we keep you from taking off the board of selectmen?
And, thank you everyone else for coming this evening.
Make a motion to adjourn?
Okay,
second.
all right, so to adjourn, and what time do we have here?
9 o'clock. No.
9:02, 9 o'clock, well, it was 9:02. Turn 9:02, and that's Milt and Terry. Discussion, all those in favor?
Okay, we're out of here.
4-0.
We done broadcasting?
Not yet.